Good morning. My name is Hayward Dykes. I'm the special magistrate. We'll be going over the magistrate court docket this morning. If you have a cell phone, please either turn it off or put it on vibrate. Anyone who plans to present any testimony or evidence this morning, if you'll please stand, I'll go ahead and swear everyone in at one time. And if you don't get sworn in but you decide to speak, just let me know. So if you'll raise your right hand, do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you all. You can have a seat. And just as a reminder, this is for the morning magistrate court docket. This is the citations, parking, things like that. We do the code enforcement after this one. So with that being said, the first matter on the docket is Kenneth Crook. You have a representative? All right. Okay, Mr. Roberts, what
I'll
case
be
are you?
ever so brief. I don't need to head on my case. I just need to move for a continuance. I want to know the county is opposed to that.
Is that on this morning's docket?
It's on the citation docket for this afternoon. I have a case management conference going in about 15 minutes with Judge Lewis, with Bruce Partington, and about 10 other lawyers.
Okay.
And I have just gotten into this file quite literally over the July the 4th holiday. I think I texted Brooke on Friday. And I spoke to Tony yesterday. Again, I want to note the county is not
So is that on the,
citation docket.
okay, what's the name?
It's Sampson. Sorry, I didn't finish
Yeah,
my thought, Your
Sampson
Honor.
Thomas?
Yeah,
Okay.
the county is not in agreement with a continuance. I just frankly haven't had enough time to even get my head into the file, and I have a conflict going on actively. Sorry about that.
Okay, so you're asking for continuance, Officer Cannon, are you here on behalf of the county?
Yes,
And
sir.
What's the county's position? You objected?
County does not agree to the continuance, but will concede to a continuance, provided that the subject ceases vending until the case can be heard.
Okay, so,
Unfortunately, my client will not agree to that, Your Honor.
okay, can you, you're kind of deep, how long is your case management conference going to be?
It's a construction defect case. I would imagine we're about 3 months from trial. I'd say it's going to be at least an hour and a half to 2 hours.
And this is to deal with,
Ice cream vending, vending without a permit on the beach.
okay. And currently because of this, they're not allowed to vend on the beach? Or-
Yes, sir. They don't have a permit through the county.
Okay, so, I mean, I guess we can handle it, you know, if he wants to keep the suspension in place, till we hear this, we can do that, or, I don't know that we're gonna have another, hearing date this month, are we? Or in the, yeah. Yeah, so it'd be August 12th would be the next, hearing date.
Your Honor, if you don't mind, I'll pull my calendar just to see. I don't believe there's
Okay.
any conflict there. But my client does not believe he's doing anything wrong. So the suspension in his mind is invalid, but
Well, I mean, he'll do so at his own risk.
I agree, and he's here in the court, here in the boardroom and can hear that. August the 12th, I have no conflict.
Okay. Well, as I said, I'm not going to touch if this is pending and there's a suspension, your client decides to vend and there's a suspension in place, he'll do so at his own risk, but we'll hear this on August 12th to give you the courtesy to go ahead and get, dig into this case.
Thank you.
Sorry to interrupt, Your Honor. So what it is it's not a suspension.
They're at the table. All right. Officer Ford, you've been sworn in. Are you ready to proceed, sir?
Yes, sir.
All right, whenever you're ready.
By the way, I asked for continuance. Is there
Oh.
I'd ask this first before you proceed.
Yes, come back up. What's the reason for the continuance, sir?
My wife is a witness. She works at Mayo Clinic in Jacksonville during the week, so she's not ever possible to be here on a Tuesday. I asked the clerk if an affidavit would be, or we could do a Zoom call, and they said that was not possible. My attorney said that a Zoom call was standard procedure in all of the courts here in Walton County, but she is the only one who can testify as to what she saw there that day.
Okay. I don't necessarily have a problem if she wants to appear by Zoom. Will you be able to get her on the phone this morning?
Quite possibly.
Okay. Well, we have these scheduled at time certain each month, so that's just kind of how they fall. So.
So I asked for the Zoom call, that was declined. I asked for a continuance, that was declined. So if we can get the continuance to August, I'd be glad to have her set up for a Zoom call. She can take time out from her schedule. She's a master's level nurse at Mayo Clinic. She just have to take off the schedule.
What's the county's position, Officer Ford?
Your Honor, I have clear photographic evidence of this violation. I don't know that a testimony from a person would make any
I also have
difference.
clear photographic evidence of no violation.
Well, hold on. Mr. Crook's, entitled to try to present his
Yes, sir.
case. If he wants to call a witness, I'm inclined to allow him to call that witness so he can try to present his case. So and I know, Officer Ford, you're generally here most months, not all months, but most. All right. So, Mr. Crook, you had asked for the August 12th
Yes.
continuance? Okay. All right. Over the county's objection, I'm going to grant Mr. Crook's request for continuance, move this case to August 12th. This case will go forward on August 12th, Mr. Crook, so you need to have whatever witnesses you wish to call or evidence you wish to present on that date.
So who do I call to set up for the Zoom?
You'll set it up yourself, and
So just
then,
use my phone?
yep, and then we'll go from there.
Thank you so much.
You're welcome. All right.
That's all I have this morning, Your Honor.
Yes, sir. You're dismissed. Thank you, sir. The next case is Paul Kahally, Kahally. Is there Mr. Kahally or Kahally here? I don't see anyone standing up. And then we have Officer McClellan. Good morning.
Morning, Your Honor.
Good morning. Are you ready to proceed?
I'm Officer Lemon
Oh,
with
you're
Walton
Officer.
County Code Compliance Parking Enforcement. I'm here today to present the case for Officer McClellan due to his inability to be here today.
Do you have, and why is Officer McClellan not here?
I'm sorry, sir.
He's, for health reasons, he's not here? Okay, so he's out. Do we know if he'll be back on August 12th? Because unless you've got personal firsthand knowledge.
I know this particular type of citation very well.
Okay. Yeah, I understand you know the citation, but I'm saying, did you witness any of the alleged violation?
I just have the photographs that Officer McClellan collected.
All right, I'll go. You've been sworn in?
Yes.
All right. Go ahead and present what you have as far as evidence.
May I approach?
Yes, sir. All right, for the record, I've been handed a copy of a citation as well as a printout for registration of a vehicle, and then 1, 2, 3 photographs of a white Mazda CX-5 with license plate RDU P as in Peter 30. All right. Whenever you're ready.
Yes, sir. On March 17th, 2026, at approximately 16:20 hours, Officer McClellan observed a white 2024 Mazda CX-5, Florida tag RDUP30, parked outside of the marked spaces at the Van Ness public parking lot. Since the vehicle's operator was not present, the citation was issued and placed on the vehicle's windshield.
All right. And these were the photographs that Officer McClellan,
Took at the time, sir, yes.
and these are kept with the county and as far as ordinary course of
I
business.
spoke with him about this case, and I have had similar cases. I've written citations on that site.
All right. Thank you, sir. All right. I didn't see anybody come in. Is there anybody? Again, I'll do one last call for Mr. Paul Cahaley. All right. Not seeing anyone, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the citation issued specifically for code 20-12B, parking violation, has been proven. Based on that, the violator is found in violation of the infraction for parking on a curb outside of a provided parking space. There will be a $100, I'll order a $100 fine, $50 clerk administrative fee, and $25 clerk processing fee for $175. I'll order that the $175 will need to be paid within 30 days. And then I'll accept the packet provided as the Exhibit A to the case. Anything additional?
No, sir, thank you very much.
Thank you, sir. Our next case is Doris Neal, and the officer is Officer David Murphy. All right, are you Miss Neal?
I want to be better.
All right. Ms. Neal, if you want to grab a seat, I'll let Officer Murphy present, and then you can ask Mr. Murphy any questions you have after he presents, and then I'll allow you to present any testimony or evidence you wish to present. Okay? So if you want to just grab, yeah, exactly. Thank you, ma'am. All right. Officer Murphy, are you ready to proceed?
Yes, sir.
All right.
Your Honor, I was on patrol in District 2, in the public parking lot on June 13th, and I was checking the fire lanes and also any violations for handicap parking. And in front of Publix, I noticed a vehicle parked in one of the handicap parking spots as I was doing my rounds. It had no handicap license plate and no handicap placard displayed on the rear window. I got out of my vehicle, I walked around the vehicle in question, because sometimes they put them on the dashboard, sometimes they're left down in the console, and I specifically looked at this vehicle. There was no placard, and I have, so I wrote a violation of 2012 for parking a handicap spot without a license or placard, and I have photographic evidence.
Okay.
I approach.
Yes, sir. And have you provided a copy of that or shown Ms. Neal?
No, Your Honor.
If you want to go ahead and show that to her before you hand it to me. Okay. understood. All right, you can go ahead. You want to go ahead and bring those up? Thank you, sir. All right, I was handed 2 photographs of a showing a Mercury Grand Marquis with license plate 793 B as in boy IU for the license plate, and then a photograph what appears to be of the same vehicle's windshield with no placard or on the dash or hanging from the rear view mirror. All right, Officer Murphy, anything else you want me to consider?
Your Honor, do you need a copy of the citation?
I think we have one. If you want to give it to me, though, we can put it in. Thank you, sir. All right, this is just a, yeah, it looks like a blown up Porsche copy of the citation issued on June 13th to Miss Doris Neal at the Publix parking lot. All right. I'll accept both the photographs as well as the citation as the county's Exhibit 1. Anything else you wish for me to consider?
No, Your Honor.
All right, thank you, sir. Hold on one second. Miss Neal, do you have any questions for Officer Murphy? Okay, thank you, sir. You can grab a seat. All right, Miss Neal?
I forgot to hang it on the mirror. I've had this for 20 years.
Okay.
And when I got out of the car, I just forgot to hang it on the mirror. And he couldn't see it because I have a pocket in the side of my door, and that's where I keep it stored all the time.
Okay. Have you seen that, Officer Murphy? Have you?
This is the first time I'm seeing this, Your Honor.
Okay. All right. Understood. Let me see it, ma'am.
Can I take it up for her, Your Honor?
Yeah, sure. I guess it'd be on the
Couldn't see it on any of those photographs from where I had it stored.
And Ms. Neal, you understand that part of the legal requirement when having those is you must properly display those, correct?
No, when I got out of the car, I just forgot to hook it on the window.
Yes, ma'am. Okay. All right, anything else, Ms. Neal?
I'm sorry?
I said anything else you want me to consider this morning?
No, I mean, I had it, I just forgot to hang it and display it, that's all.
Understood. All right,
I just don't want to pay you $250.
yeah, I understand. Nobody does. All right,
I know you're a nice man, but you're not worth $250.
yeah, I think my wife would agree. Okay, you can grab a seat. All right, anything else, Officer Murphy?
No, Your Honor.
All right, thank you. All right, I'll close the evidence portion of this hearing. I'll make the following finding. Based on the testimony and evidence, I'll find that a violation has occurred in reference to improper display, or no display in this case, of the handicap placard. I will reduce the fine from $250 to $50. Hold on one second. There's also a clerk administrative fee. I'm going to reduce that to $25. So the total, ma'am, is going to be 75. There's no clerk processing fee? Okay. So your total is going to be $75. You'll pay that. Can you pay that within 30 days? Well, I'm not going to take your money, but it'll be the clerk's office will take your money. Can she pay that later today? Or?
Yes, you can play it later this afternoon.
Yeah, we'll just need the clerk's office, so you can either do it over in South Walton, or you can do it in Defuniak. We'll give you a copy, and you can, contact them. You can probably even pay it online, I would think. Oh, sorry, my bad.
Can I go now?
Yes, ma'am, you're done. Thank you.
That's the only case I have, Your Honor.
All right, you're dismissed. Thank you, Officer Murphy. All right, our next case is Kevin Pittman, and we have Officer Esquivel. Mr. Pittman? All right, if you want to grab a seat, Mr. Pittman, just like the last couple individuals, we'll let you come up and ask questions of Officer Esquivel once he presents. All right, are you ready to proceed?
Yes, Your Honor. Can I give you, hand out the packets?
Yeah, if you want to do that now.
Mr.
Have you
Pittman.
given want to give one to Mr. Pittman as well?
Yes, sir.
Thank you, sir. All right, whenever you're ready.
Good morning, Your Honor. My name is Diego Esquivel, and I work as a Walton County Code Compliance parking officer. On the 21st of May of this year, at the Blue Mountain Regional Beach Access parking lot, I observed a silver 2016 Harley-Davidson bearing Florida license plate XCHIP parked on a striped handicap access aisle and out of a marked space. You can refer to the photos included in your package, specifically number 1. I issued a citation using Ordinance 20-12B for not being parked in a marked space. Now, the citation was mailed due to the motorcycle leaving before I was able to hang the citation.
All right, so while you were writing the citation, the owner came out and left the
Yes.
area?
Yes, sir.
All right, so no contact whatsoever with, I guess, Mr. Pittman?
No, sir.
Okay. Anything else at this time, Officer Esquivel?
No, sir.
All right. Mr. Pittman, do you have any questions for Officer Esquivel?
Yes, I do, Your Honor.
Okay, come on up. You can ask Officer Esquivel, he's got some questions he's had for you.
On that Memorial, I believe it was Memorial Day weekend. Went out. I recently got out of surgery for Crohn's disease, and I've been out of work for 2 years. I had a Definiak turned me away from the hospital with my 3rd-degree burns. So I was just now getting out, and I was parked on the right side of the
Well,
lines.
Mr. Pittman, do you have a question?
The question is, the left side is where the handicap was. And then he came, when we parked, there was no writing on that. Someone got a piece of chalk and put no parking on the left side. And I was on the right side where the curb is. I've seen, why don't golf carts and Jeeps get ticketed when they're there? Because I've been back July 4th, and there was a Jeep, and there's no parking for motorcycles there. And I thought, instead of taking a whole parking place for handicap, which I got rid of my veteran tag, disability tag, and got a handicap, because they told me, even if you have a veteran handicap, if it doesn't have the wheelchair on there, you're going to get a ticket. So since then, I went and got my doctor's okay because of the issues that I'm having, and I have a handicap tag now. But the veterans, they said you can still get a citation, the disabled tag. So now I have a handicap tag. And I was at the beach laying out. I didn't just see him and leave. I never knew it until a month or so later. I have to go sign for something at the post office, and it's a citation. I don't even know where it was at. It said Blue Mountain, but I wasn't sure either that or at the Goat Feather, because that's the only 2 places I go over there. I live in Ponce de Leon.
So, again, Mr. Pittman, did you have a specific question for Officer
Specific, well,
Esquivel?
they wrote 2016, it's a 2025 on, motorcycle. That was wrong. And the other citation is for when I had my other bike. I got 2 citations.
Okay, Officer Esquivel, so is the question why he got 2 citations, or?
The question is, why would that be a handicap when it's to the right? The handicap, it was clearly marked with chalk after we got there on the road with chalk. You can barely see it, but it says no parking, which is on the left side. I was on the right side close to the curb, and it was not saying handicap there. And then there's golf carts there all the time, and I see no tickets on them.
So what was the question again?
The right side is where I was parked.
Okay.
So is your question, because you parked on this side in this
Right.
section, is that a
Why
valid parking spot, Officer Esquivel?
That is not a parking spot, no.
Okay, why is that not a valid parking spot?
Because that is a handicap access aisle for that marked space where the vehicle's parked in.
Right, so it's marked off because it's part of the handicap spot so people can get in and out of the handicap
Correct.
or their vehicle, I guess, that's parked in the handicap.
Correct.
All right. And have you been trained or instructed that if vehicles, whether they're motorcycles, golf carts, or any other type of vehicle that parks into that part, that is not a valid parking spot, and to issue citations?
Correct. Yes, sir.
Okay. Do you, Mr. Pittman, did you have any other questions of Officer Esquivel?
No, sir.
Okay. All right, now, Mr. Pittman, now's your opportunity. I know you were going into some other things about why you were there and some other issues. Now's your opportunity to present any testimony you want. So I'll open up the floor for you.
Okay, well, I had a veteran's disability tag on my motorcycle, and I parked far enough to be out of the way of if there was a car there, but they could get clearly out. I was parked all the way forward. And I found recently, they told me at DMV that tag that I had was not going to keep me or allow me to park in handicap. So I now have a handicap tag, wheelchair, on my motorcycle.
All right, and just so we're clear, Mr. Pittman, the only citation that I'm considering this morning is failure to park in a marked parking space.
Okay, well, they had them both moved to the same, I have both papers here from Phoenix Springs, moving them both to the 8th. And they stamped it and everything.
Oh, does he have, you have another case?
Yes, sir.
Yeah, we're not hearing that
like
case right now. That we'll deal with that one in a moment. So this one is a violation of failure to park in a marked parking space. The other one that you have is handicap parking violation. That was issued by a different
It's the same
officer.
place, so,
Understood, but it was issued by a different officer.
okay. And
So we're
like I
just gonna-
said, my tag that I had on there was not going to, I did not know that I could not park in handicap. I mean, disabled veteran is not a tag that's going to keep me from, it doesn't allow me
All
to
right,
park.
so this is Officer Esquivel's testimony, is his citation is because you parked here, which is not a
Right,
proper
well, I'm
parking
handicapped. I mean, I'm.
All right, so that's not a handicap spot. That's a handicap spot there. This is part of all this is considered a handicap spot.
Okay, well, I didn't
So-
want to take up a whole parking place for a motorcycle.
Understood. So, but that also, I don't know that provides you an excuse to say, well, I'll just park here, because I don't know whose handicap vehicle that is, what they need as far as space, but that's carved out as space so they can get in and out of their vehicle.
Okay.
Without having to, maneuver.
So
by
next
another
time I'll just park in the whole allotted space.
I guess so.
Yes, sir. That's what I'll do. I'll
All
take
right.
them.
Anything else, sir?
No, sir.
All right. Anything else from you, Officer Esquivel? No, sir. All right. At this time, I'll close the evidence portion of this hearing. I'll make the following findings. I'll find that, based on the testimony evidence presented this morning, there is sufficient evidence to find a violation has occurred, and I'll order and adjudicate that a $100 fine will be imposed. In addition, there's a $50 clerk administrative fee a $25 clerk processing fee for a total of $175. Mr. Pittman, can you pay that within 30 days? Okay. I'll order that it needs to be paid within 30 days. You'll get a copy of that order. And then you can just stay right there, Mr. Pittman, because we have this other matter involving the handicap parking. And I'll give you another chance to present on that as well, but that's Officer Knudsen. Do we have? Okay. Officer Knudsen, you want to come on up?
Morning, Your Honor. My name is Nicole Knudsen, and I work as a Walton County Code Compliance Parking Officer. On June 13, 2026, at the Blue Mountain Regional Beach Access Parking Lot, I observed a silver 2016 Harley-Davidson motorcycle bearing Florida license plate XCHIP parked on a striped handicap access aisle area. Please refer to the photos included in your packet. I issued a citation using Ordinance 2021C for being parked in a handicap access aisle.
Okay. Do you have any photos or copy of the citation? Have you, yeah, and have you given a copy to Mr. Pittman? All right. All right, so as Mr. Pittman testified, was this on the same day?
No, this was the 13th of June, and
Okay. Okay. And I've got a copy of the citation, printout of the registration, and then photographs of the vehicle. Did you make any contact with Mr. Pittman?
I did not.
Okay. All right. Mr. Pittman, do you have any questions for Officer Knudsen? No, sir. All right. And Officer Knudsen, you can grab a seat if you wish. Mr. Pittman, I think I'm going to give you an opportunity if you want to speak on this one. This was similar to the last citation. Looks like, you parked in the same area in that part of the handicapped parking space. In this case, there does not appear, at least at the time of the photograph, that there was a vehicle in the handicap spot. Officer Knudsen, let me ask you, the fact that he has the veteran tag, is that not sufficient for being able to park in a handicap spot, as Mr. Pittman testified to earlier?
He's in the access aisle.
Yeah, I understand that. But had he parked in the handicap parking spot, would that have been a violation? Okay, and
Why?
why?
My supervisor.
Well, my question is, if his tag is
I've been disabled since I got out of the service, and I'm pretty sure that was a disabled tag.
This shows veteran, that's
okay. So, as
old veteran.
Mr. Pittman said, he would have to have the disabled, is there like a different tag? It
Yes,
says
there
Yeah,
is.
disabled
that's
veteran?
what, Sheriff.
Okay.
And I did. I turned that tag in because I found out at the DMV that that's not going to allow me. I'll still get ticketed. So I said, well, I want the handicap tag, and I got it. And I got proof that I have it.
So since this time, when did you get the handicap tag?
After I seen a ticket on my motorcycle going to the beach, parked over there, I could have parked in the space, but I didn't want to take up, like I said, I didn't want to take up a whole space for a motorcycle. And it says the compact cars is just asking to get a ticket because that's for golf carts. So I could have took the whole place, but I didn't. I parked off and all the way up so that it'll allow a handicapped person to park there. From now on, I'll just take up a whole parking place.
Yeah, understood. Well, and that's what I was trying to get at, right? If you
Yes,
had if you had a tag that says I'm allowed to park in disabled spots, and you
Well,
you
I had,
hold on, and you parked, you know, in or near this spot, then I would probably try to look to see if I could give you a little relief.
yes, sir.
But you don't have the proper tag, and then you know, the last one was more of, you know, somebody who did have the proper, you know, credentials, so to speak, parked in that space, and you took up the access aisle. Now, if you had the proper tag, even though you're in the access aisle, you know, I could see, well, hey, maybe he just,
Well, I did not know that a disabled veteran tag didn't allow me to park there, and until they told me. I mean, because I had CDLs all my life, and recently, since this incident when my third-degree burns on my legs, they came after me. But then they threw that out of court because of the state trooper no longer drives for the state of Florida. But that was another whole thing. But this is, I mean, it's just, I'm trying to do the right things, and that's why I got rid of the veteran disability tag and got the handicap tag. I mean, I've had that tag, been disabled for quite some time, and now I got plastered for my truck and a tag for my car,
okay.
the right ones, not this veteran, the veteran disability tag.
Yeah, this tag, and I'm no expert on all the, Florida has a bunch of tags. This one just says veteran, but this is a disabled veteran tag, to your knowledge?
To my knowledge.
Okay. All right. Officer Knutson, do you know if this is considered a veteran, or is it supposed to say disabled somewhere
Should
on it?
say disabled somewhere on there.
Okay.
Vehicle license plates for disabled veterans have the DV
Okay.
and followed by the numbers.
All right. Okay.
Well,
so-
they don't, the veterans don't have the wheelchair on them.
Right, but some do, or they'll say DV.
Okay.
I didn't know, but I'm clear, I know
Yeah.
now, because I don't want to keep getting tickets, and
Oh.
I'm not a person to go out and do wrong.
No, sir. We understand. All right. Anything else from Mr. Pittman?
Sir?
I was just asking, is there anything else you want me to consider?
No, sir.
All right. Officer Knutson, anything else from the county?
No, sir.
All right. I'll close the evidence portion at this time. I'll make the following findings of fact. I'll find that, based on the testimony and evidence presented, I'll find that a violation has occurred. Where's his last order? I know this is probably going to be of little consequence, Mr. Pittman, but I'm going to order that it's reduce the $250 fine to a $100 fine, similar to your last case. There is a $50 clerk administrative fee. And then, is there no processing fee? Okay.
Well, on this ticket, the first one, it said 116, or no, 125. The other one said 250, so the
So
one you're talking about.
we reduced the one from 250 to 100, sir.
Okay.
Okay? And then you're going to have a $50 clerk administrative fee. So for the other ticket, it's going to be 150 instead of the 300 that was requested by the county. And can you make that payment within 30 days?
What's the total?
For both tickets?
Yes, sir.
Is going to be $325 total. If you need a little extra time, I don't mind giving that to you.
A little extra time.
Okay, so I'll order the $150 ticket will need to be paid within 60 days, okay? So you have 30 days for the one for 175, and then the other one you'll have 60 days to pay it, so about 2 months.
Thank you, sir.
Yes, sir. All right?
Your Honor, that was my only case, maybe
Yes,
dismissed.
ma'am, thank you. All right. And Mr. Pittman, appreciate you showing up this morning, and good luck to you, sir. Have a good day. Our next case is Julia Cheeverman, and we have Officer Escobar on that case as well. Is someone here for Julia Cheeverman? Okay, not seeing anyone. Are you ready to proceed, Officer Escobar?
Yes, Your Honor.
All right, whenever you're ready.
May I approach with a
Yes.
packet?
Thank you, sir.
On the 14th of May, at approximately 3:40 p.m., I was patrolling near Oyster Lake in West County, 38 Highway, when I observed a black 2016 Buick Encore bearing Florida tag number Z29ZY parked within a no parking area. I issued a citation using ordinance 2014, which you have a copy of there. I did not make contact with the owner at all. And once I issued the ordinance, I took photographic evidence of it. As you can see, there's multiple vehicles that were cited for the same reason. As Cheverman was cited as well.
All right, so I have a copy of the ordinance, copy of the registration printout for the vehicle, and then the photographs of a black in color Buick Encore, tag Z29ZY. So are there other, so are these kind of bookends of this area? So that's the vehicle we're talking about, correct?
Yes, Your Honor. There's
Right.
multiple no parking signs.
And then this one is on the other side?
Correct,
Kind
Your
of
Honor.
bookend? And is that the vehicle there in the middle?
That is correct, Your Honor.
Okay. All right. All right. I'll accept into evidence the photographs as well as the other documents presented by the county. Is there anything else, Officer Escobar?
No, sir.
All right, thank you, sir. I'll close the evidence portion of this hearing. I'll make the following findings, and I'll find that there has been sufficient evidence based on the testimony and evidence presented to find a violation of the infraction of Section 20-14, designating no parking areas. Based on that, I'll order and adjudicate that there will be a $100 fine, $50 clerk administrative fee, and $25 clerk processing fee for a total of $175. I'll order that the fines and fees must be paid within 30 days. All right, our next case, Sampson Thomas. That one has been continued. We're going to move to, actually, he has two of them, so we'll move both of those. 3, 4, 5. Actually, is that one? Okay, so there's actually 5 of them.
Your Honor, those were my two cases. May I be dismissed?
Yes, sir. So we're down to Matthew Tripoli. Is Mr. Tripoli here? And then we have Officer Adams, Robert Adams. Mr. Tripoli, just like before, we'll have Officer Adams, so if you want to grab a seat, and then we'll let you present and ask questions. All right, Officer Adams, you ready to proceed?
Yes, Your Honor.
All right, whenever you're ready, go
I
ahead.
bring
Yeah.
photos to you, sir.
All right. And has Mr. Tripoli seen these or got copies? Okay. And I've been handed 2 photographs of a Ford, looks like a F-150, and a license plate JS239, either a 0 or a D at the end. All right. Whenever you're ready, Officer Adams.
Yes, sir. Community Service Officer with the Walton County Sheriff's Office. I was doing a foot patrol at the on 30A, and there's a shopping center there. And in the back of it, there's a lot of parking. And as I was doing the foot patrol, I saw a truck parked in the handicap with its flashers on. As I passed by it, I looked, I didn't see any handicap stickers or anything. I went on back around the building, did my entire walk around, came back around, and it was still there in the still with the flashers on. No one was in the vehicle that I saw, and there was no sticker that I saw. And so I went back to my truck, drove it back around, and it was still there. So I issued a ticket at that time. As I was finishing the ticket, I noticed the person come back, was talking to someone. I looked down and started finishing my ticket, and as they backed out, I think I even had to move a little bit because I cannot block anyone in, and I wasn't intending to. But he backed out and left, so then I mailed the ticket to him.
Okay. What would you estimate your entire time was as far as seeing when you first noticed the vehicle circling the property, and then when the vehicle
I would
backed
say
out?
at least 10 to 15 minutes.
Okay. Did you get a look at the driver?
I noticed someone coming out and coming towards it, writing the ticket, and I did not. I noticed it was a young man
Okay.
talking to a lady.
And you confirmed the ownership of the vehicle was Mr. Tripoli?
I ran the plates, yes, sir.
Okay. All right. Mr. Tripoli, do you have any questions for Officer Adams this morning? Okay. Officer Adams, if you want to take a seat. Mr. Tripoli, if you want to come on up, I'll hear any testimony or review any evidence you wish for me to consider.
My mother owns that store right in front, and I was just coming to drop off some stuff to her, and then because I'm her son, she just wanted to talk to me for way too long. Definitely guilty as charged, though, for parking in the handicap.
Understood.
ChatGPT told me that, yeah, for sure, I owe the $250
Okay.
and
Well,
the $75.
All right. Well, we appreciate your candor, Mr.
You're welcome.
Tripoli. Thank you, sir. All right. Anything else, Officer Adams? All right. I'll close the evidence portion of this hearing. I'll accept in the evidence the photographs and testimony and evidence presented. I do find that based on that, there is a sufficient evidence to show a violation has occurred, specifically a violation of handicap parking. Mr. Tripoli, again, thank you for your candor. Based on that, there is a $250 fine, a $50 administrative fee for a total of $300. Mr. Tripoli, can you pay that within 30 days? Okay. All right. If you need more time, I don't mind if you want 30. I mean, I'd give you 45, 60. Okay. I'll order that it be paid within 45 days. Mr. Tripoli, you're going to get a copy of your order. Whenever you're ready to pay that within the next 45 days, you can do that through the clerk's office. Thank you, sir. Thank you. I think that concludes our citation docket for this morning, so we are adjourned on that one. Thank you.
You were sitting in the shade right there, and I was like, oh, he's probably
All right. I'm going to go ahead and call to order the July 8th, 2026 Code Compliance Hearing Meeting. My name is Hayward Dykes. I'm the Special Magistrate. I'll be hearing the matters this morning. At this time, if you can, we'll all stand and do the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all. You can grab a seat. I've signed and approved the minutes. Are there any announcements regarding the agenda? Okay. I don't know how many of you were here earlier going through the other cases, but if I swore you in, you don't have to be sworn in again. But anyone who plans to testify or present evidence this morning, if you will please stand and raise your right hand. And these are for people who haven't been sworn in previously. All right. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? All right. Thank you all. Our first case is 26-0103, and the property owners are Joannis and Catherine. I'm going to Coetzee. Okay. Is Mr. and Ms. Coetzee or representative for the Coetzees here? All right, come on up, sir. Good morning. Are you Mr. Coetzee or Dr. Coetzee? All right. Good morning, Dr. Coetzee. I don't know if you were here earlier, but for all the cases, we allow the county to present first. You'll have an opportunity to ask any questions of any county witnesses, and then I'll allow you to present any testimony or evidence you wish for me to consider, all right? So if you want to grab a seat. All right, is the county ready to proceed?
We are, if I may present out the packet here.
Yeah. And does Dr. Coetzee have you got a copy of the packet as well, Dr. Coetzee? Okay.
Good morning, Your Honor. Officer Harold Serrano, Walton County Code Compliance. For the record, I'm submitting the final summary case report and testimony for case number 2600103. Property location at 210 Casa Grande Lane, Santa Rosa Beach, Florida, 32459. Property owner Dr. Johan and Catherine Coetzee. Property is an unincorporated area of Walton County and is subject to the Land Development Code Chapter 7 and the county ordinance. Violation cited is 1.13.06 post-permit change, 4.03.03 shoreline protection, and 7.02.03 dilapidated structure. On February 14, 2026, I conducted an initial inspection of the property and observed a dilapidated structure on site that appeared to be in the process of demolition. Demolition debris from the structure was piled within a damaged structure. Following the inspection, further inspection of the property through aerial footage of the county appraisal site showed that there had been modification and alternation performed inside the base shore protection zone. I reached out with Brad Bond and the Environmentalist and Planning Department for guidance on whether the property in question required a restoration plan for the rear of the property and inside the shoreline protection zone. He informed me that it was determined that the property would need a restoration plan on top of a DEP review per the Planning Department. Between March 20th and 21st, notice of violation was certified mailed and posted to the property. On March 25th, 2026, I met with the property owner and their contractor, Mr. Craig Cole, at the residence for a follow-up inspection and scheduled to discuss the notice of violation that had been posted. Upon review of the violations in detail, I obtained a clear understanding that the property owner's situation, explaining that the delays in the addressing the issues were due to the insurance company withholding funds from a fire incident, which had been prevented from moving forward with necessary work to bring the property in compliance. The owner had also informed me that their recent meetings with Planning Department with Brad Bond had stated that began the application process. Their intention is to also have the restoration plan incorporated into the development order with the planning department. On March 31st, I had spoke with the property owner informing that the demolition permit had been updated and that they were currently in process in the scheduling meeting with the BPR status. On April 15th, 2026, a notice of violation extension had been granted to the property owner and a certified mail copy, as well as posted to the property. On May 15th, 2026, I met with the property owner and their contractor at the code compliance office. They requested the meeting to discuss the expected timeframes for the compliance process and steps required moving forward. I informed them that as of this date of May 15th, no application had been submitted to planning department and no adequate updates had been provided by either the property owner or the contractor from last spoke with the updated demolition permit. They informed me that they were waiting on architectural plans to move forward with the required planning documents for the BPR application, and a BPR application was finally submitted on May 28th, 2026. As well as May 28th, a notice of violation extension additionally had been granted for 30 days, bringing the new compliance date to June 27, 2026. On June 26, I hand-delivered a notice of hearing to the property owner and at time of service. I also conducted a pre-hearing inspection, as you can see in the packet. I would like to submit my packet into evidence at this time.
I'll accept that into evidence. Have you, since scheduling of this hearing, have you checked the system? Has there been any progress as far as?
They have had minor progress on the BPR status. Believe they're requiring some additional documentation from Mr. Brad Bone, an environmentalist. They have been actively communicating with me that they have some meetings to obtain with Brad to keep that process moving in a positive direction.
Okay. Is the entirety of the structure in the shoreline protection?
Not the separate, they're kind of two separate things, Your Honor. The dilapidated fire is within the actual physical property itself. The shoreline protection is a completely separate violation on that.
So what's the, I guess that's what so I see photographs of some things that were done behind looks like the main structure of the home, some of these photographs, so.
Yes, sir, that's part of the shoreline protection out, that before and after is out, where they had the sand as well as the allotted square footage of the docks on that protection zone that was going over the seawall there.
Right.
And then, of course, you can see the front photos of the actual burnt remnant of the burn
Right.
fire.
Yeah, I see that part, and I can see the burnt wood within the structure. So I was trying to determine what are the violations as it relates to the shoreline protection if it's not the actual structure issue as far as, so with the dock or the sandy area?
It would be within that the shoreline protection zone where it's all built in within that protection zone from that seawall beyond out with, I believe it's 50 feet within that shoreline protection zone there where they had built out over that seawall. That would be that protection zone there.
So the remedy for that would be to remove the extra build out over the seawall?
Correct, yes. And they have started that process. Fortunately, the whole overscope of work hasn't been fully approved with the planning department, but they have taken action to do that, as well as communication with the DEP.
All right. Anything else?
No, Your Honor.
All right. Dr. Coatsey, do you have any questions for Officer Serrano? Okay. If you want to come on up to the podium.
May I bring Mr. Cole?
Yeah, so that's your contractor, Mr. Cole?
Yes, Craig Cole.
Okay. All right. And but, Mr. Cole, you were sworn in earlier?
Yes, sir.
All right. All right. Whether it's Dr. Coetzee or Mr. Cole, who wants to start?
Well, all I can say, Your Honor, is that we intend to comply 100% with all of the stipulations that Mr. Serrano has voiced this morning. And any technical questions that they may have, I think Mr. Cole will be better suited to answer those.
It seems like you guys understand the path forward. You just got to get with the county to kind of get, is it your understanding there's some additional documents the county's waiting on?
Well, we've got 3 violations, and I think that if we can address, the first violation was with the EPA or DEP on the dock and the footage. Dr. Coetzee has met with representatives of the EPA, and he has removed the square footage needed to bring him back into compliance. So that is done.
So we'll need a reinspection for that just to confirm that that's been done by the county?
Well, I don't think it falls under the county's review. It's really an EPA review. And if my understanding, I'll let Dr. Coetzee speak to that because he handled that, is that he is in compliance and they are not going to require another inspection. Is that correct?
We had notification from Mr. Budd out of Pensacola, the DEP agent there, that if we bring it in under the 1,000 square feet, then we will be in compliance. There won't be any further action taken by.
Do you have something from them that says we've been out and we confirm that it's under 1,000?
No, they haven't been out since we've started demolishing the structure.
I think what he's asking you is, after your meeting, do you have any documentation that we're in compliance, or do we need to get that from?
No, we still need to.
Okay, so, yeah, it sounds like, well, somebody's going to come out and say,
Right.
yeah, you're under.
Another inspection.
The
Yes, sir.
1,000. So may not be the county, but something that you can show to the county says,
Yes.
hey,
Yes.
DEP's been out there. All right.
All right, then the second is the bayshore protection. And over the years, since he finished the house in '07, he's added stuff to the back, which is not in compliance. So what we are trying to do in our application to the planning department, bring that bayshore protection in under our request for planning department review and our permit for the repair or repairs to the fire damage. So that's in the process of doing that. And the third violation is the dilapidated building. And what we did after the insurance had finished their inspections and all, we secured a demo permit, and we have removed all the life safety issues in the areas that were unstable back to the shell of the building. And then the building has been wrapped with a tarp for water protection. If I read the ordinance, I don't think the building really falls under a dilapidated building violation. So I guess our request would be to get that out of the system and just comply with the bayshore protection zone that we have and that we're in the process. But we're also paralleling that with our process for our permit for planning approval and then a building permit.
Okay. Officer Serrano, what's the county's position on Mr. Cole?
Yes, Your Honor. For clarification on that, the scope of work, if he has with the DEP's communication out, as long as he brings the paperwork that provides compliance with our environmentalist, that would be fine under that. We could drop that protection out zone on that. That would be great. It just needs to go through the proper channels to our planning department for that citation. The dilapidated structure, however, even though he does have a demolition permit, he would still need to obtain a remodeling permit due to the fact that it still is dilapidated. So if he obtains a remodeling permit, that could suffice for compliance for that particular violation. I know it's under the scope that he was trying to incorporate everything, so the restoration plan and the remodel was kind of all in one. He can divide that up if he chooses, just to help him out with the process and have one complete scope of work. He was trying to integrate all of them, but at this time, all violations would still be standing.
Right, so I guess my question is, even though Mr. Cole has a demolition permit, does it not sound as though they intend to completely demolish this structure? They've
Correct.
removed all the life safety issues, and I guess are gonna either do a remodel or whatever you wanna call it. As
Right.
far as that goes, so.
He would just need to obtain a remodeling permit, Don, to drop that dilapidated structure violation, because there's nothing in, he doesn't have an approved process for the planning department yet. So if you wanted to get a remodeling permit, that would suffice for that time being to be in compliance. It's just a matter of which direction they wanted to go. My understanding, they're trying to do a whole big picture and make it into one chunk of approval.
Yeah, understood. And I guess the complaint that came in was related to the state of the property, not so much the shoreline protection, but the state of the property and the fact that some of the tarps or maybe some other waterproofing that was in place had.
Yes, sir.
Had failed or started to fail and blew into other people's yards. Okay. All right. Anything else, Dr. Coetzee or Mr. Cole?
I think our only other challenge, Your Honor, is we're now at the mercy of the planning department and the time frame to get through that. We've had a couple meetings. They've requested a couple of additional items from us, which the architect is in the process of getting, and then it goes back into the review process.
Yes, and I'm somewhat familiar that can be lengthy. But it does, as I said earlier, it does sound like you kind of know the path forward. You just need time to get it done. Is
Yes,
that
Your Honor.
a correct statement? Okay. What's the county's recommendation in this case?
Yes, sir. We recommend that 90 days to achieve a compliance, $250 per day fine to accrue with a $122 admin fee.
Okay. All right, Dr. Coetzee, so what you heard there is what the county's asking to be imposed if a violation is found. That would be that you have 90 days to bring the property into compliance to try to get your permits in place and get whatever other things you need taken care of. Should you not get in compliance within 90 days, a $250 fine and a $122 administrative fee. As Mr. Cole pointed out, some of these things are going to be out of your control, but I will say generally 90 days is the most amount of time I provide for property owners to allow them to try to bring the property in compliance. If you take longer than that, you can, that happens sometimes, but you can always come back and ask for a fine reduction to show that, hey, we were working and we did everything we could as quickly as we could. County had some hang-ups, but we got it done, and it took us 100 days or 120 days, right? But we got it done. So do you have any comments or anything additional?
No, we accept that, Your Honor.
Okay. All right. Well, we appreciate both of you. If there's nothing else, I'll allow both of you to grab a seat. All right. Thank you. At this time, I'll close the evidence portion of this hearing. I'll accept into evidence the county's packet and the testimony and evidence presented by both the county as well as Dr. Coetzee. Based on the testimony and evidence presented, I will find that the property located at 210 Casa Grande Lane in Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I will also find that there's sufficient evidence to show a violation has occurred on the property, specifically a violation of 1.13.06 post-permit changes, 4.0303 shoreline protection, and 7.02.03 dilapidated structure. Based on those findings, I'll order that the property must be brought into compliance within 90 days, so that'll be on or before October 6th. Should the property not be brought into compliance on or before that date, a $250 per day fine will be imposed. In addition to the fine, there is a administrative fee of $122. That will need to be paid regardless of whether or not the property is brought into compliance. Dr. Coetzee, can you pay that within 30 days? Okay, I'll order that needs, the $122 will need to be paid within 30 days. And that's paid at is that paid through the clerk's office or paid at your office? Okay, so the $122 will be paid at code compliance office, so you don't pay that at the clerk's office, all right? I've signed that order. Dr. Coetzee, best of luck to you. Thank you, and that concludes your case. All right, our next case is CE 25-1992. The property owner is listed as Tammy Beach, and the property address is 35 Possum Lane in Defuniak Springs, Florida. Is Miss Beach here, or someone on behalf of Miss Beach?
No, sir, she's not going to be able to be present.
Okay.
May I approach from a packet?
Yes, sir. And county's ready to proceed this morning? All right, great. Thank you, sir. Whenever you're ready.
I'm a Code Compliance Officer Greg Forehand. For the record, I'm submitting my final summary report, presentation, and testimony in reference to case number 2501992. This property is in the unincorporated area of Walton County and subject to Chapter 7 of Land Development Code, located at 35 Possum Lane, Defuniak Springs, Florida, and belongs to Miss Tammy Beach. Violations being pursued on this date are 1.13.00A alpha development approvals, 1.13.09C Charlie building permits, and 2.02.00 or 00 P Papa RV and campers. A complaint was received on 12/30/2025 in reference to potentially non-permitted structures and setback concerns. On 1/10/2026, an initial inspection was conducted by CCO Neenan, a Code Compliance Officer Neenan, validating multiple small structures on the parcel, with one appearing to be in the front setback, along with RV appearing to be used as a primary dwelling. Further research showed a conditional use allowance for the RV in 2021 granted temporary use as a dwelling while trying to get a primary structure on the parcel. On 2/11/2026, I took over the case, conducting inspection, validating the structures, vehicles parked in the right-of-way, RV living, and some miscellaneous junk and debris concerns, with the condition of some portable storage structures exposing items to the elements. On 2/12/2026, notice violations were prepared and placed in certified mail, and then also posted to the property on 2/17. 2/19/2026, I had interaction, phone contact with Ms. Beach, discussing the violations listed and corrections needed. She was very concerned about the water well being beneath the shed near the right-of-way, but Public Works had already advised they will not require it to be relocated. Once I advised of the expectations, there were continued interactions and efforts being made with debris cleanup, the removal of portable storage buildings, and vehicle parking moved from the right-of-way onto the property. On 3/10/2026, a clearing permit was applied for, which required a wetland delineation, an updated survey. Once that was approved on 6/5/26, the work began on clearing on 6/11. And at that time, I did suggest that Ms. Beach move along with getting plans drawn up and submitted showing the location and type of structure she'll be using, but there is yet to be anything updated in the portal. On 6/25/26, I prepared notice of hearing, posting it to the South Walton Annex, and hand-delivered it to Miss Beach on that same date. Yesterday on 7/7/26, I returned to the property obtaining pre-hearing photos showing violations being pursued still present. There were also no updates in the portal showing plans for a primary structure. I would like to turn in my packet as evidence.
All right, that'll be accepted in evidence. The, all right, as far as Officer Forehand, you said you'd spoken to her, she's, Miss Beach.
Yeah, she had a last-minute conflicting appointment that came up, and I advised her that I could speak in her behalf.
Did she provide any, anything to you as far as current status, if she was gonna take your advice and they were in the
Yeah,
process?
she has plans to go with a partially like a prefab type tiny home, and there was some financial tie-ups that created delay in that. But she does seem motivated and wanting to do that. That's why she had to get the clearing permit. She had to clear a portion to be able to get it pulled into the property to the location she wants it's installed. And as for everything, most of the things she's been able to get accomplished has been on the physical aspect and with the clearing permit, and now it's just a point of the final step with the structure.
What's the county recommendation on this?
I advised her I would attempt to get the full 90 days, being she's trying to get the everything in order to get the structure there. And then, of course, there'd be a daily fine of $100 until it is compliant.
All right, thank you, sir. At this time, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 35 Possum Lane in Defeniak Springs, Florida is in the unincorporated area of Walton County and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I'll find that there is sufficient evidence to show a violation has occurred at the property, specifically a violation of 1.13.00A, development approval requirements, 1.13.09C, building permit requirement, and 2.02.00P as in Peter, RV and camper living. I did note that Officer Forehand, as you indicated, there was a conditional use order issued for this property by the Zoning Board of Adjustment in 2021 that did allow for the approval of temporary or seasonal use of a recreational vehicle at this property, but based on your testimony and the evidence presented, this looks like it's not temporary and not seasonal in nature. So I do find that violation has been sufficiently proven. Based on the county's recommendation, I'll order that the property must be brought into compliance within 90 days. That's October 6th. Okay. Should the property not be brought into compliance on or before that date, a $100 per day fine will be imposed.
We have $113 in administrative.
The $113 in administrative fees will also be imposed, and they'll have 30 days to pay that. All right, our next case is...
That was my dismiss, sir.
Yes, sir. Thank you. Next case is 260291. The property owner is listed as the Roger Cheatham Trust, and the address is 160 Maple Street in Freeport. Is someone here on behalf of the Cheatham Trust? Okay, you're Mr. Roger Cheatham? All right. All right, great. All right, Mr. Cheatham, just like we've been doing the others, we'll allow them, and then you can ask questions. All right?
Approach to give you your packet.
Yes. And Mr. Cheatham, did you get a copy of this? Okay. All right, Officer Neenan, whenever you're ready.
For the record, I'm Officer Rachel Neenan, Walton County Code Compliance. I'm submitting my final summary case report and testimony regarding case number 26-00291. Property owner is Roger Cheatham. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and county ordinances. The violations cited are 2.02.06 Rural Village and 5.07.09C non-operating vehicles, junk and debris. On May 4th of 2026, our office received a complaint stating that there is junk and debris and RVs on the property. On May 5th of 2026, I conducted my initial inspection and found that the first house, which is a brick home, did have an RV, but no evidence of RV living. The second house is a blue home and did have some junk and debris, and a metal building looked like it was a business, but there was no signage of a business. It did have equipment and non-operating vehicles and junk and debris. The vacant lot that is separated and has the same parcel number had a building on it and a huge pile of fill dirt. On May 12th of 2026, a notice of violation was given as prescribed by code. At this time, no contact has been made with the property owner except for one interaction at the property. On June 17th of 2026, a notice of hearing was given as prescribed by code. Photos in your packet show the initial inspection and pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
That'll be accepted into evidence. Explain to me what the rural village violation is, 2.02.06.
Commercial activity at a residential property.
All right, so it's just that activity on the property is not allowed in that zoning district?
Correct, yes, sir. With the fill dirt being at the top and then evidence of commercial equipment on the property. Also, there is toward the back of your back of your packet, there are multiple business Sunbiz accounts that are associated with the address. Exhibit 17, 18, and 19, which lead me to believe that a commercial business is being held in that property.
You said you did have one encounter with was that with Mr. Cheatham?
Yes, sir.
Okay. And what happened during that encounter?
Did a lot of screaming and waving his arms, and I told him to back away, and I got in my vehicle and left.
All right. All right. Anything else, Officer Neenan?
No, sir.
All right. Mr. Cheatham, do you have any questions for Officer Neenan? Yeah. Okay. You want to come on up? You can ask your question.
If you did those homework, I've been in business since 1984, Cheatham Hall. I paid taxes and all out there on that land. I built that building at Cheatham Hall. That metal building was put up at Cheatham Hall. The land on the highway is industrial property, and that's not fill dirt down there stacked up. It's rock for a project I'm going to be doing there. And far as the junk, I've been working on the junk. In the trailer, no, it was my trailer, but since y'all protested me, I went on and drove that out my. I didn't know I lived in
Mr. Cheatham,
Blue Water Bay.
One second. Do you have a specific question that you would like Officer Neenan to attempt to answer? And I'll let you present. I'm just saying this isn't a time to try to dress down Officer Neenan or anything like that.
I ain't trying to dress nobody down.
Okay, but I'm just saying, if you have a question, if you want to ask her if she did something or didn't do something, or,
Why have I done wrong?
So when I spoke to the planning department, they told me that there was no record at all of there ever being an approval of having a commercial business on that property. It would have to be zoned something other than rural village for you to be able to have that hauling business there.
I've been there since 1984. Nobody ever touched me or said nothing.
Okay, hold on.
So the metal building was put up.
Hold on, Mr. Cheatham. So would there be any grandfathering in for the business if it's been in business since 1984?
Yeah.
The building was built in 2005, which would not make it grandfathered in. And when I spoke to Lisa Day about it, it does not state that it says a residential miscellaneous building. It does not say that it's a commercial building or that it's for commercial use.
Well, if I'd had,
That's Exhibit 16.
I'd have had the old record, it said shop on it. When I built that thing for a shop in 1984. In 2005 when I got the building up.
I mean, that's.
than
this
the
is a
land on the
resi-
highway down
All
there.
right, Mr. Cheatham, let's try not to speak over each other.
All right.
So I do have on Exhibit 16 a printout that shows that there was an application put in May of 2005 for a residential miscellaneous building shed. And so we have those records, the county has those types of records?
Correct, yes, sir.
Okay. And Mr. Cheatham, you're not saying that building wasn't, that was for the building we're talking about today, correct?
Yes, sir.
Okay.
That's all I've ever did there is work on my dump trucks and my equipment. I've never did nothing else. It's always been for myself. No.
All right. And then
I dissolved the corporation this year in April.
is that Cheatham Hauling that you
Yep, I
mentioned earlier?
dissolved that
Okay.
after 40 years. I dissolved it in Walton County. Because I'm 66 years old.
Yeah, it does show that, at
just
least
can't-
on the SunBiz, that you've had it in as an ongoing business since at least 95 on their
Yeah.
records. So,
And I've always been out there. I mean, I was the first one out there. At one time, I go ahead and tell you that they wanted me to have my kids go up there to Highway 20 and catch the bus. I clayed the road in front of me because the county wouldn't help me out. So I clayed that where my youngins could get picked up in front of the house. I built that road, really. Then they come along and paved it.
you talking about Maple Street?
Yep.
Okay. So,
I furnished all that clay to do that whole road. Which where they'd pick my youngins up right there at the house instead of up there on Highway 20.
so as far as let's first deal with what I think I would be kind of the easier one to get our arms around, the junk and debris. You said you've started.
Oh, I've done haul off 20 loads of junk in the morning.
Okay.
It's just so much, 30 days wasn't enough time. And now, may I present something to you?
Sure.
I'm gonna tear that house down. Next door. I got it in June.
Okay, hold on, go back over there. I'll hand this back to you. So you handed me a copy of a building permit, issued
got
on
it.
June 1st?
Yeah.
Okay. Have you seen this? Okay, I'll give it back to him. He can show it to you. So,
Because I'm gonna demo that house too. If I'm gonna clean up, you gotta look. I'm gonna clean the whole place up.
okay, here you go. You can have that back if you want to show that to Officer Neem.
I just wanna clean the whole place up since I'm cleaning up.
Yes, sir. So what do,
I've had a bad year, My baby got run over. She's 8. I know I'm old. I'm 66, but she got run over out there on checking the mail at the mailbox in July the 15th with a FedEx truck. Because the old FedEx driver said he couldn't see her because the grass was too high in the county ditches, like I told him. I hate it, but I stayed 2 months over in Pensacola for that. I've had a lot of, then just the other day, the 12th, I got in a truck accident. My truck's got $35,000 worth of damage. I can't take it to the shop because I'm still trying to clean up because I pulled a 16-yard trailer behind
right.
my truck.
Well, I think we can get you some time to,
That's my whole thing. I ain't got a problem. I'm ready to clean it all up. But the only thing is, were they showing down here on the highway, that stuff piled up down there? I got 5 acres down there.
Yeah.
Well, anyhow, me and Charlotte Flint, we changed the zoning on that back in 99, I think. We went to industrial.
That's the property that's on
the highway.
Highway 20. Yep.
Yeah, so I shouldn't have a problem with stacking that rock up down there. That's what I did, I own Black Creek Pit. Right over here, I own Black Creek Pit. I sold it in January. We had cleaned that place up. I sold it. Really, all I've been doing for years is cleaning up. Tell you the truth, I don't even have a job. I filed for my Social Security in April. I don't even have a job.
Well, yeah, I think we can definitely work with you
And that's my main thing. I don't want to hide it behind a fence. And the other thing, this thing don't say nothing about heavy equipment. It says cars and trucks and junk. Well, I had to go up to Southern Tire Mart, and I got Todd to give me some tires on credit, and I got 2 on yesterday. I'm trying to get the other 2 on today or tomorrow as soon as he gets them mounted. I'm trying to get all that equipment moved on some land in Ponce de Leon. I'm trying to move it all up there too.
Understood.
'Cause
So
it's still good stuff.
So let's talk about so if you were given some time, just throwing numbers, 60 days, 90 days.
60 days.
You'd be.
By the end of August, I should have it.
Okay.
I should have it demoed by then.
Okay.
So but I'm older and I don't have much help on my youngin.
Understood. He
My
looks
other
like
son.
he's strong though.
He's my baby son.
All right. So then let's go back. I think I've got an understanding of the junk and debris part of it. As far as the building in the back that the county's claiming is being used for commercial purposes.
Yes, I've used it, always work on my dump trucks, my equipment, all personal, you know what
All
I'm
right,
saying?
so-
Cheatham Holland.
So your testimony is that you're using that to work on personal equipment that you own.
That's right.
Okay. All right.
Like our cars, anything we gotta work on, we work on it there. I don't work on it in the house, cause I own 5 lots there.
Yeah. And so again.
Really, I was the biggest landowner in there, I am.
Understood. So your testimony is you do not use that building or that
work.
for commercial
Yeah.
purposes. You don't charge
Just
people.
my own stuff.
Right. Okay.
That's all it's ever been there for. It's always, because it's my equipment, no.
Okay. Officer Neenan, what's the county's response to that if Mr. Cheatham's testified that well, it looks like a commercial building.
Well, if you look at all the
hold on.
excuse me.
Yeah, just let me ask the question. So outside of it, having kind of the look of a commercial building, do you have any other evidence besides the Sunbiz that building is being used for commercial purposes?
No, just besides the commercial equipment that's there. I haven't seen the dump truck back there since I've.
We sold that blue dump truck. We've been getting rid of stuff I have left and right. If I don't buy it, I give it away. I'm just ready to clean up.
So
I've never had no problem.
So besides the dump truck, I see that there's some heavy equipment, but to Mr. Cheatham's point, if he owns that equipment, I mean, he would be allowed to work on that personally, right? Okay.
That's all my equipment.
Uh,
But I'm trying to get it out of there, like I told you. I'm trying to get it up because I need it up there on my farm I bought in Ponce de Leon.
and what about the dirt pile, excuse me, that you took a picture of? I know Mr. Cheatham had mentioned that, and the reason that's included, remind me, Exhibit 6.
It's just on the same parcel showing the hauling of the
What they
dirt or
do,
rock or that you had said.
Okay.
what
So,
excuse me, what they do on my land taxes, they just put it all together. And I ain't never understood that, but they always did that. But me and Charlotte Flint changed the zoning on this in '99 to industrial property.
And I did a lot of research on this parcel as to why, because normally when
talking
you
about the
have.
front parcel, right? The
Yes,
one- yeah.
yes, sir, the one that goes along Highway 20. I contacted the property appraiser, I contacted GIS mapping, trying to find out, because normally when you have one parcel like that, it's not so far away. But nowhere, they said that it is one parcel and it's a rural village. I don't, all
Yeah,
I can
it's-
go by
it's
is with
rare
what they're
for
saying. It is
one
very
parcel
rare.
to have two zoning,
But you
right?
know,
Like a front and zoning.
ever since '84, ever since I loaned it all, that's how they've always did it. And I've never understood that.
I've also never seen a parcel this far apart have the same parcel number and be combined with it not being adjacent. So this was a rare point for me.
Okay.
But me and Charlotte Flint changed that land in like '99 to industrial. I had Charlotte Flint to help me because I used to do a lot of work for Charlotte Flint back in the day.
Now, Officer Neenan's testified, I haven't checked personally, but that at least for purposes of the zoning map and what the county recognizes that your property, both parcels, is that they're both considered, the front piece and the back piece are both considered rural village.
Correct.
So,
It's considered one full parcel.
right. And so what you may need to do, Mr. Cheatham, is go back and find those records, or.
Well, that's what I got. I got an engineer working on it. Really, what I was fixing to do there, I'll go ahead and tell y'all, I was fixing to build a boat and RV storage. And that's why all that rock's there, because I brought it from Black Creek Pit to there, because I had it crushed. There's like $150,000 worth of rock in there. Because I was going to do like a storage and just spread that rock. All it's going to go on that land.
Yeah. I'm looking at the.
Crushed concrete, what it is.
At least what's showing up on the property appraiser. It says, property use, single family.
Charlotte, we got something on it. I had to pay something like 30 grand to change that. And the industrial.
So.
That's been a while back.
Officer Neenan, did you go to the property appraiser's website and research how this is zoned?
Yes, sir.
So I'm looking at the property appraiser's website as well, and to Mr. Cheatham's, it does appear that front parcel along Highway 20 is zoned, or at least shows on the property appraiser's website, zoned heavy industrial.
Approach.
Sure.
I know I spent money changing that thing.
Let me go back. There's that one. There's that one. And 160 Maple. Okay. Okay.
I've never seen, I think when it pulled up, it just had this in the rural village. I've never had two parcels have two different zonings.
Obviously, there's an issue, so.
On this land a lifetime.
Yeah, I'll admit that's a mistake on my part.
All right, so what I did is I had the opportunity to show Officer Neenan the property appraiser's website, punched in the address for 160 Maple Street. It does show, at least through the property appraiser's website, that front piece off of Highway 20 is listed as 160 Maple Street to the Roger Cheatham Trust, and it shows that as heavy industrial. It does show that back portion, that other piece off of Maple Street, the one where that shows that as rural village. So.
One time I was going to put the shop down there, but then it was so far from the home when I worked till like 1 o'clock in the morning. I just put it over here.
So.
But anyhow, Your Honor, I'm trying my best to get it all cleaned up.
Yes, sir, I can tell. So the rock or that pile of dirt or rock, whatever that is, okay, is
I don't think
up on
that
the
it would
front.
be an issue if he's not using it to haul and sell for commercial activity. I don't think it would be an issue at this point.
Okay.
I've been offered $40 a ton for it, and I don't want to sell it. There's like $150,000 worth of crushed concrete.
Yes, sir.
And I need it all for that, because I said I got my nephew down in Jacksonville. He's an engineer. He's
So,
working on my plan.
Hold on, Mr. Cheatham, I'm trying to get
Okay.
you to the end so we can get on to these other cases. So as far as the rural village portion, the only issue there would be left would be the allegation of the commercial use for that building, correct?
Correct, yes, sir.
Okay.
I don't.
So your
work in
testimony.
Nobody else's stuff there.
All right, and then, Mr. Cheatham, the Circle C Farm LLC, does that sound familiar? Did you? Okay, and that's got the mailing address for 160 Maple Street. What's Circle C Farm? Hey, if you can stay by the microphone.
Circle C Farm is my land up there in Ponce de Leon.
But you just have your mail and stuff sent?
Yeah.
out? Okay.
I mean, that my address up there is, what is it, 2967 R.E. Ward Road.
Okay. And then Cheatham Holland, you said you.
I dissolved
you
that in
dissolved that
April.
one?
Yes, sir.
All right.
That's why I'm saying, that's why I didn't, when they come to compliance me about cleaning up, I didn't care, because you know what? What I've been through in the last year, let me tell you, I just don't want no problem.
Understood.
Let me just get everything cleaned up. That's why I pulled the demo permit, where I could demo that house. I started at my house, and I'm going all the way.
All right. Well,
I want to be able to mow it.
understood. All right. Thank you, sir. What's the county's requesting on this or recommendation?
Recommendation was 30 days to achieve compliance or $250 per day fine to accrue with a $122 admin fee. That was before I'd had an interaction with Mr. Cheatham to where we've actually conversed about what's actually happening on the property.
All right.
So I'll leave that up to you.
All right. Thank you.
So I've worked every day, and that ain't counting my cousin I had out there. He's 65. He ended up dying in the shop, 13th. Because I take it back. He died the 15th in my shop out there, so we had to take off a couple of days to bury him.
Okay. Well,
The only time I don't rain if I'm burying somebody
right.
or it's raining.
Understood. Well, I appreciate you coming in, Mr. Cheatham. You provided some compelling testimony and did confirm some things that appears the county was unaware of. So.
No, I've lived out there, like I said, since I was one of the first people to live out there.
Right. All right. Well, I'm going to go ahead. I'm going to get Mr. Cheatham. You can go ahead and grab a seat. I'm going to close the evidence portion of this hearing. I'm going to make the following findings of fact and conclusions of law. I'll find that the property located at 160 Maple Street in Freeport, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I'll make a finding that there is sufficient evidence to show a violation has occurred, specifically a violation of 5.07.09C, junk and debris. I do not find that there is a violation of, or sufficient evidence to show a violation of 2.02.06 Rural Village at this time. Based on the Mr. Cheatham's testimony, and I understand the county has asked for 30 days to bring the property into compliance. Based on what Mr. Cheatham testified to, I'm going to provide him with 60 days. He believes within 60 days he'll be able to get the property into compliance. You'll need to have the property re-inspected after you believe you've removed all the junk and debris. When's that? All right, so we're actually going to give you 61 days. So you're going to have on or before September 7th to bring the property into compliance. That's specifically the junk and debris. In the event that the property is not brought into compliance on or before that date, a $150 fine will be imposed. As I told other property owners, even if you don't get it all done by that date, as long as you can show you're progressing, you can come in and ask for a fine reduction potentially if you overshoot that date. But try to meet that date if possible. There is a $122 administrative fee. That'll need to be paid regardless of whether or not you bring the property into compliance. And I'll order that be paid within 30 days. Is that going to be a problem? To pay that $122 in 30 days? No, you're going to have to, they'll send you a copy of the order. And then you'll have, yeah, they'll. Yeah, and then you just have, yeah, either mail it or you might have to swing by. Yeah. And I'll just make the comment, while the county did do its homework as it relates to the business, I do find that Mr. Cheatham's, testimony that he only works on personal equipment and vehicles. There was nothing to contradict that other than SunBiz, and having your address, home address on SunBiz is not equivalent to running a commercial activity. So that's why I didn't find for Rural Village. But obviously, if the county has further information or evidence to present on commercial activity, we can rehear that at a future date. But as of today, I don't believe the county carried its burden. So the only violation, Mr. Cheatham, just so you're clear, is just the junk and debris. So again, once you believe you've completed that, call the county. They'll come out, re-inspect, confirm that, and then that'll resolve that issue. Sounds good. All right.
I'll go ahead and get all the junk and debris out from the shop, then I'll get the county back.
Excellent. All right. Thank you, sir. That concludes your case. You're free to go. All right. Our next case is 260051. Property owners listed as Seascape Resorts Incorporated.
May I approach?
Sure. And I see Mr. Tatum coming up. All right. Both the county as well as Seascape Resorts ready to proceed? All right, great.
For the record, I'm Officer Rachel Neenan, Walton County Code Compliance. I'm submitting my final summary case report and testimony regarding case 26-00051. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and county ordinances. The violations cited are 1.13.06 post-permit changes. On January 27th of 2026, our office received a complaint stating that changes were made to the amphitheater and North Pond. On January 28th of 2026, I conducted an initial inspection and found that changes had been made to the venue area and a portion of the North Pond had been filled. A stop work order was issued at that time. On January 28th of 2026, a notice of violation was given as prescribed by code. The venue area has since been resolved. Currently, Seascape is working on getting a less than minor for the North Pond changes and has been working with the Water Management District to obtain the necessary documents. Several inspections have been completed throughout this case, and the stop work order has always been adhered to. I did receive an email this morning, which is not in your packet, but they have submitted the comments that the planning department was requesting. So right now, it's just a review of those that step and portion of that. On June 22nd of 2026, a notice of hearing was given as prescribed by code. As of today, the less than minor has not been approved for the property to come into compliance. Photos in your packet show the initial inspection and pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
All right. Mr. Tatum, I'm assuming you received a copy of the packet. Any objection?
No objection.
All right, that'll be accepted into evidence. You have any questions for Officer Neenan?
I do not.
All right. And if you're ready to present on behalf of Seascape Resorts.
Afternoon, Your Honor. For the record, Stephen Tatum here on behalf of Seascape Resorts. Really very simple. This is the only outstanding issue is some filling that happened at the North Pond that is that the changes were actually shown on the development order plans, just they were outside of the development area, so it never got reviewed. We made the changes. There was never any review of it. Since that time, and it was called, we have been working with the county and then the Water Management District on permitting what changes were made. The changes or what work was done. It is going to require some tweaking based on the Water Management District comments. It's been a little bit of a slow roll process between getting planning comments and Water Management District comments, but we're at the finish line at this point.
Okay. Were you the one who sent the email to Officer Neenan?
I am not. That would have probably came from Chris, who was our engineer. Oh, and Kelly Schultz.
All right. So All right, so it sounds like we're in the process. How much time do we think it's going to be or needed for?
For the sake of covering everything, can you give us 90 days? I don't think it'll take that long, honestly, but you know how state agencies can be.
Yeah, I know how state agencies, I know how county agencies can be.
Oh, county agencies are great.
I know how municipal agencies can be. So what's the county's position?
90 days to achieve compliance or $250 per day fine to accrue with a $122 admin fee.
So it looks like they're in line with the 90 days. You got any comments on any of the rest?
No, I do not.
Okay. All right, thank you both. All right, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusion of the law. I'll find that based on the testimony and evidence presented, that the property located at 2105 Devereux Circle, oh, I'm sorry, that's the address. This is the Seascape Common Area. Doesn't really have an address, so the parcel ID is 292S 21425 00000000, is in the unincorporated area of Walton County, Florida, is therefore subject to the Walton County Land Development Code. Based on the evidence presented in the testimony, I'll find that there is sufficient evidence to show a violation has occurred, specifically a violation of 1.13.06 post-permit changes at the property. Based on Seascape Resort's request and the county's agreement, will order that the property brought in compliance within 90 days. That'll be October 6th. Okay. In the event the property is not brought into compliance on or before October 6th, a $250 per day fine will be imposed. In addition, there's a $122 administrative fee. Mr. Tatum, I'm assuming 30 days would be sufficient to pay the admin fee?
Yeah, that would be fine. I kind of just have a problem paying it, but.
All right. Understood. So I'll order that will be paid within 30 days, and that concludes that case. Thank you, guys. All right, our next case is 260341. This is the estate of Charles Currington. The address is 281 Piper's Landing Road in Defeniak Springs. Is there anyone here on behalf of the estate of Charles Currington?
No, Your Honor.
Okay.
May I approach?
Yes, ma'am. Thank you. And county's ready to proceed?
Yes, sir.
All right, whenever you're ready.
Good morning. I am Officer Sarah Madrano, Walton County Code Compliance Officer. I'm here today presenting case 26341 involving the property located at 281 Piper's Landing Road with the owner listed as the estate of Charles W. Currington. The violations cited included 7.02.03 dilapidated structures, 3.02.02 overgrowth, and 5.07009C exterior storage and non-operating vehicles, junk or debris. It should be noted that 5.0709C is a repeat offense, as the property owner was adjudicated January 14th, 2026 for the same violation. The property had been previously brought into compliance as of March 9th, 2026. An order of imposing fine recorded with the clerk's office on April 9th, 2026 reflects an outstanding amount of $3,450 along with a $95 administrative fee. On May 28th, 2026, I conducted my initial inspection. During this inspection, I observed a dilapidated mobile home with holes in the siding, junk and debris throughout the property, and grass exceeding 18 inches in height. Also, a white SUV was on blocks. A notice of violation was mailed on June 5th, 2026, A follow-up inspection was conducted on June 12th, 2026. All violations remained present. During this visit, I spoke with the property owner and informed him that the fines were accruing due to the repeat nature of the junk and debris violation. The owner stated that the ongoing porch repairs contributed to some of the debris. A notice of hearing was mailed via certified mail and posted both at the Walton County Courthouse and the property on June 12th, 2026. Walton County Code Compliance is requesting that the property be found in violation.
All right. So there is somebody living at the property.
Yes, sir, multiple people.
The, what's the county recommendation?
30 days, or pay $250 per day until compliance is achieved. Additionally, I'm requesting that the repeat violation for junk and litter be assessed a daily fine of $250, beginning on May 28th, 2026, which is the date of my initial inspection. The total amount is $10,500.
What was that date again? May what?
May 28th, 2026.
Is the exterior storage, is that just the white SUV or is there something else?
That includes exterior storage, but it's the non-operating vehicles, junk and debris that they're in violation. It's
Right.
exterior ore.
So the other debris, is that the, you got photographs of, looks like a pallet with some bricks, with some overgrowth or weeds growing out of it in the foreground of the SUV picture, and then I see in the back corner, maybe by the tree line, there's also some storage of junk and debris. Is that cumulative?
Yes, sir. It's actually gotten worse since my first initial. You can see initial inspection on 5/28. Exhibit A is from follow-up inspections. Exhibit B is from this last inspection, including Exhibit C.
Yeah, it looks like, are they erecting a fence? Or are they attempting to erect a fence, or is that just leftover? I see like a
They
partial
just
fence.
started putting that fence up within the last couple of weeks.
Are they, if they screen that, if they end up putting up that fence, would that resolve the, I guess, the exterior storage issue? I know some places in the county you can put up screening or fencing. Other
Yes, sir.
places you
So that would, if they screen the property and I can't see anything from the county right away, that would really cure all the violations.
But they don't have that as
No,
of
sir.
today. Okay. And what was the total requested on the repeat? I know it's $250 a day from May 28th, 2026, and you gave me the total as being how much?
Yes, sir. It's $10,500.
And when you spoke to the, I guess, the residents, I don't know that there's a specific owner since it's in the estate, did you advise them that this would be a repeat, or you'd be requesting a repeat? Be treated as a repeat offender and seeking the enhanced?
Yes, Your Honor.
Okay. All right. Anything else from the county?
No, sir.
All right. And you want to introduce your packet into evidence?
Yes, sir.
All right. I'll accept that into evidence. All right. Thank you. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 281 Piper's Landing Road in Phoenix Springs, Florida is in the unincorporated area of Walton County, is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I find that there is sufficient evidence to show a violation has occurred at the property, specifically a violation of 7.02.02 overgrowth, 7.02.03 dilapidated structures, as well as a repeat offense of 5.07.09C exterior storage of non-operating vehicles, junk, or debris. Based on the county's recommendation and request, all order of the property must be brought into compliance within 30 days. So that'll be August. All right, on or before August 7th. In the event the property is not brought into compliance on or before August 7th, a $250 per day fine will be imposed. Did you tell me the admin fee? Is that 122, or what's the admin fee on this? Or is there one?
Yes, Your Honor, it's 122.
All right. I'll order $122 in administrative fees. That'll need to be paid within 30 days as well. And in addition, having found this to be a repeat offender, a fine of $250 per day will be imposed on the repeat offense for the exterior storage, junk and debris. And based on the county's request, that accumulated fine will be $10,500 from the May 28th date and $250 per day until brought into compliance. All right, I've signed that order. The next case is 260195, Justin and Christine Neal. And the address is 200 South 2nd Street in Santa Rosa Beach. Are you Mr. Neal? Yes. Okay, great. If you want to grab a seat, Mr. Neal, and then we'll let the county present. Is the county ready to proceed?
Yes, Your Honor. I am Officer Sarah Medrano, for the record, presenting case 26-00195 for 200 South 2nd Street in Santa Rosa Beach. May I approach?
Yes, ma'am. Thank you. And Mr. Neal, did you get a copy of the packet? So that should be the same packet that the county just provided to me. So if you want to be looking through that. All right. Sorry about that. Go ahead.
I received this case on March 21st, 2026, based on the complaint on too many vehicles creating traffic. During my case research, I reviewed historical aerial imagery and identified noticeable landscape alterations to the backyard on the property. These changes occurred sometime in between 2022 and 2025. The aerial imagery indicates that either gravel or concrete was placed, covering most of the rear yard area. Clearing can only occur with an approved BPR for property south of the bay. The extent of the material placed is a violation in that a modification has occurred that requires planning review to ensure impervious surface limits and stormwater considerations. On March 28th, I posted and mailed a notice of violation and spoke with Mr. Neal, the homeowner, regarding the violations. He admitted that material is gravel and was done after the property was purchased in 2025, correction. On April 26th, a BPR application was submitted to the planning department. On May 7th, 2026, an extension for the notice of violation was approved for an additional 30 days. I certified, mailed, and posted the notice of hearing on June 11th. That same day I spoke with Mr. Neal. He stated he hired an engineer and a surveyor to complete the stormwater plan. I would like to submit my packet into evidence.
All right. I'll accept that into evidence. Now, what's the status? Looks like you said the BPR application was put in
April 26th.
Yeah, April 26th. And then have you checked the status prior to the hearing today?
Yes, Your Honor. I see that it was submitted and it's being reviewed. I did notice that the charges weren't paid on this BPR, so that may be a hiccup in the process in the building department. I did notice that this morning that it's still in review.
Okay. Yeah, do they do reviews if you haven't paid the charges? I thought that was one of the
I believe
requirements.
so. They're waiting on documents from the property owner.
Okay. All right. Thank you, ma'am. Hold on. Let me ask if Mr. Neal has any questions for you. Do you have any questions? All right. And if you want to come up, Mr. Neal, I'll hear any testimony or evidence you want me to consider.
Yeah, I'm just looking for more time. Apologies for how long it's taken. It has been painful, I will admit. So this was done unaware of the impervious surface area. That gravel basically is like concrete. I thought it would be treated like grass. That's my bad. And the surveyor I hired, he was my original surveyor, so I just stuck with him. He was booking a couple weeks out. That couple weeks ended up being 4 weeks. And then my engineer was out of town after she got started for 2 weeks on vacation. So it's just been really poor timing, and it's been a slow process. But I've been in communication with my engineer from Baker, Michelle, and we have a plan. Now it's just hiring someone to implement the stormwater plan. So as long as I get more time, I will get it addressed.
How much time are you thinking you're going to need?
I mean, everything's been taking long, so I'd like to give myself some pad in 60 days, 45 days. I think it'll be less than that, but.
Okay. Well, yeah, I mean, I think it's always a smart move to give yourself a little bit of cushion if you can, in case somebody goes on vacation or
Yes, sir.
gets sick or whatever. Okay. I appreciate that. Anything else, sir?
No, sir.
All right. What's the county recommending on this?
Yes, Your Honor. We recommend 60 days to obtain compliance or a $150 daily fine.
And is there any admin fees?
Yes, the admin fee is $131.
Mr. Neal, so the county's, you heard they're requesting that 60 days to bring the property into compliance. If it's not brought into compliance, $150 per day fine, and the admin fee is kind of what they charge for all of this, right, to have the hearing and everything like that. But do you think 60 days would give you enough time?
Yes, sir.
Okay. Because, I don't mind considering longer time if you think you need it, because you have no control over the professionals that you hire.
I've learned that. Yeah. I mean, I think 60 will suffice. Yeah.
Okay.
Thank you, though.
All right, not a problem. All right, appreciate it. Thank you, guys. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. You can grab a seat. I'll find that the property located at 200 South 2nd Street in Santa Rosa Beach, Florida is in the unincorporated area of Walton County, Florida, is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I'll find that there is sufficient evidence to show a violation has occurred at the property, specifically a violation of 1.13.00A, development approval requirements. Based on Mr. Neal's testimony and the county, I'll order that the property be brought into compliance within 60 days. That's going to put us, or 61, yep, September 7th, so you get it 61 days. If the property is not brought into compliance on or before that date, a $150 per day fine will be imposed. And as I told others, Mr. Neal, if something happens, get it done. Even if you overshoot, you can always request a fine reduction, right? So if it takes you an extra 10, 20 days, don't let that discourage you. In addition, there's a $131 administrative fee. That'll need to be paid regardless of whether or not the property is brought into compliance. Can you pay that within 30 days? Okay, I'll order that be paid within 30 days. All right, Mr. Neal, I sign that order. Best of luck to you. And that concludes your case. Yep. All right, our next case is the Robert and Cheryl Cheatham Revocable Trust. Do we have any representatives here for Robert and Cheryl Cheatham? Okay. All right, good morning or afternoon. We're still kind of morning. Afternoon. Ms. Cheatham, just grab a seat and then Is the county ready to proceed?
Yes, Your Honor.
Okay.
For the record, my name is Officer Sarah Madrano, Walton County Code Compliance. May I approach?
Yes, ma'am. And Ms. Cheatham, did you get a copy of this packet as well? Okay, good. Thank you.
I'm here to present the case involving the property located at 133 Cypress Street in Freeport, Florida. The case number is 26-00294. Property owners are Robert and Cheryl Cheatham. This case concerns violations of Section 1.13.00A, Development Approval, and Section 1.1309C, Building Permits. On May 6, 2026, I conducted an initial inspection on the property. During my inspection, I observed an accessory structure that was over 400 square feet located on the property. A review of county records showed only one permit had been pulled, which was an electric permit in 2006. No development approval or building permit was ever issued for the accessory dwelling. A notice of violation was hand-delivered to the property owner, Ms. Cheatham, and mailed on May 12th. I explained the violations to her at that time. On May 19th, 2026, a building permit application was submitted and denied due to not having the BPR approved. I contacted Ms. Cheatham and provided her with a step-by-step instructions on how to apply for the BPR via phone and text message. A notice of hearing was mailed via certified mail and posted at the the Walton County Courthouse and hand-delivered to the property owner on June 17th. On June 29th, a BPR application was submitted to the planning department. However, as today, the BPR application is under review and no permits have been issued. Therefore, the property remains in compliance. This time, I'd like to submit my packet and evidence.
All right, that'll be accepted into evidence. So that they've applied. So is it now in the county's hands? And
Yes, Your Honor. She applied just a week ago on June 29th. So it's under review.
all right, anything else from the county at this time?
No, Your Honor.
All right, Ms. Cheatham, do you have any questions? All right, if you have any questions of Officer Serrano, go ahead. I'm sorry, ma'am, if you don't mind, come up to the microphone. We record these, so just so we're
Can
trying
you explain to me why you were out in our area?
Yes, ma'am. We received a complaint for junk and debris on your property.
Was it my property? It says here in my papers that it was 57 Cypress Street, and you came to my property.
So there was also a complaint on the neighboring property put in. When I'm doing my research, I conducted the research, and I didn't realize that the property had been split. I saw the junk and debris on your neighbor's property.
Across the road?
No, it's on the same side of the road as you.
About Larry Cheatham?
Yes,
Yes.
ma'am. And so I looked on my GIS and saw this is not the right parcel ID number. Come back, and I spoke with my supervisor. She advised, we looked over it. There was a complaint on your property as well as your brother-in-law's property?
Yeah.
Yes, ma'am.
Okay, for what I understand from the county, the property was across the street, and that's not my brother-in-law.
No, ma'am.
That's where the campers were, and that's where the junk cars were.
So the parcel ID.
That's 57.
The parcel ID was addressed to your address. It was your property that was complained on. Oh, the complaint was put on.
Okay. Your Honor, that's the only question I have for her.
Okay, great. Go ahead, if you want to grab a seat.
Yes,
And now's an opportunity, Ms. Cheatham, if you want to present any other testimony or evidence.
Yes, I just would like to say that my husband built this shop. It's been probably there for 15, 20 years. I had no idea at the time that he did not get permits for the property, and he has since passed away. So all this has just been thrown on me, and it's really taken a toll on my health because I'm trying to deal with, loss and loneliness, and I'm doing the best I can.
Understood. And it looks like you've started the process.
Yes,
You've
I have.
done the application, so it seems to me like some of the others, you just need some additional time to get it through the system.
And I don't know what else, what else I can do. I've turned in everything they asked for.
Well, yeah, I mean, the county will normally get back with you on any deficiencies. Sometimes people will submit, like an example, maybe submit a survey, but the survey's older, so they'll ask for a newer survey. So that'll take time to get those types of things in order. But my experience has been that, the county will attempt to work with property owners to try to, get them to the finish line, so to speak, to get that done. So the good news is it sounds as though you've taken the first step, so we just need to probably give you some time so the county can review it, and if there's additional information the county needs, you can get that to them. Let me do this. What's the county requesting in this case?
We request 60 days for compliance. If not, within 60 days, $150 daily fine.
Is there any admin fee on this?
$122.
And the application was just submitted like about a week or so ago?
Yes, Your Honor. As I said, she submitted a building permit at first,
Right.
but unfortunately, it needs to go through planning to begin with, and then she can apply for that building permit.
Okay. So has she started that process, though?
Yes,
Right,
Your
she's
Honor.
done the application through. So have you had your meeting with planning yet?
I spoke with Paula.
Okay. Yeah, I don't, normally the planning will have a meeting with you to determine if there's anything else.
I haven't had a meeting.
All right. I'm gonna err on the side of caution and probably lean towards giving Ms. Cheatham the maximum amount of time to try to get this, since she's doing this on her own, it sounds like, and trying to bring the property into compliance. So, all right. Anything else from the county?
No, sir.
All right. Anything else from you, Ms. Cheatham?
I would like to see the paperwork, clerk or whatever, fine, reduced, because it was, to me, she came to my property without even being called and told anything. I mean, I just feel like I'm being harassed. And if my husband was here, he would help with all this, but like I said,
Well, and just so we're clear, there's no fines that are going to be issued today. So you're not going to get fined. We're going to try to give you some time to, and if you don't in the future bring the property, you don't get the permits, maybe you just say, hey, screw it, I'm not going to do anything, then fines can begin to accumulate. But, we want to give you a chance to try to,
yeah.
do
Yes.
what you're doing.
Okay.
So, I just want to make clear, there's no $150 starting today, right?
Right.
So none of that's going to occur right now.
Right, but like I said, the clerk charges or whatever, 122 or 32 or whatever.
Yeah, those are administrative fees that
Yeah.
are charged on every case, and that's part of sending out notices,
Right.
staff
Well, if you'll
time.
notice, the same date that she fined me, she also that other one fined my brother-in-law. So there was something going on in that whole neighborhood that day, and I'm not sure what it was.
Yeah,
Roger Cheatham, when he was here earlier.
right. Yeah, I have no idea. I don't deal with that. But, all right, anything else, Ms. Cheatham? All right, thank you, ma'am. You can grab a seat. All right, I'll go ahead and close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 133 Cypress Street in Freeport, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that there is sufficient evidence to show a violation has occurred at the property, specifically a violation of 1.1300A and 1.1309C. Even though the county's requested 60 days, I'm going to order that the property be brought in compliance within 90 days. So that'll be on or before October 6th, Ms. Cheatham. And I want to give you that extra time because, you know, a lot of this is out of your control on how quickly the county reviews things. In the event the property is not brought into compliance on or before October 6th, county's requested a $150 per day fine. I'm going to reduce that to $100. But do be advised, Ms. Cheatham, that if you don't bring the property into compliance on or before October 6th, a $100 per day fine will be start at that point and will continue to accumulate until the property is brought into compliance. Hold on a second. And then there's a $122 administrative fee. I am going to order that. I'll order that be paid within 30 days. And now I'll go ahead. Yes, Ms. Cheatham, what was your question?
Just talking about what?
I went over the last part was the admin fee. Right before that was the timeline. You have until October 6, 2026 to bring the property into compliance.
Provided the county can do their part? What if it's all, you know, mixed up with them? I don't know what to do if they don't do what they're supposed to do. Do you think they'll come up through with their part
Well, they're obligated.
within 90 days?
They're obligated to do their part. Now, whether or not it's in 90 days, I don't know, right? But what I'm saying is if you overshoot, say it takes you to October 31st, right? And you finally get your permit and you're good to go, you can come in and ask for a fine reduction and say, hey, look, the delay wasn't my fault. County took this long to do it, right? But what isn't looked upon favorably is where they say, hey, we need an updated survey, and then you take 6 months to go get a new
I wouldn't
survey,
do that.
right? So, but then again, you may get a surveyor and they just say, hey, we're so busy, we can't do it for 6 months.
Right, like that one guy,
right?
yeah.
But then you may need to look for another surveyor, right? Like, hey, I don't have, time isn't a luxury I have. I'm trying to get this done. So,
And I was told, Your Honor, and you can answer this for me, that the people we brought the property from should have this survey?
well, if you bought the property, usually as a buyer, you're going to have a survey unless you accept a survey that a seller has.
Okay, so I should have a copy of the survey.
Maybe.
And the people I bought it
Yeah,
from?
because and it matters, it's different for different things, right? Like
Yeah, this was back in 92, so I don't.
So
I'm not
yeah, if
sure.
you have a survey from 92, they're probably going to make you get a new survey.
Okay.
That one's.
Yeah, that's when we bought the property.
Right, so you may have to, but get with the county and try to find that out. If you have a copy of the survey, you can find it. Just that being so old, I'd be surprised if they didn't tell you had to get an updated survey to show where everything's at. Because the other thing would be on some of these is they want to know where the building was built to make sure that you're not violating any setbacks or anything.
We've talked about all that with the planning.
All right, so any other questions? All right, best of luck to you, ma'am. That concludes your case. You're free to go. Their next case is 26-10100. Property owner is listed as Dune View LLC. Are you gentlemen here for Dune View? Okay, great. And the property address is 7588 East County Highway 30A in Inlet Beach, Florida. All right. Is the county ready to proceed?
Yes, sir.
Okay, and is Dune View LLC, are you guys ready? All right, great.
Officer Uriel Baza with Walton County Code Compliance. For the record, I'm submitting my final summary case report and testimony regarding case number 26-00100. May I approach?
Yes, sir. And were you gentlemen, do you have a copy of the county's packet? Okay, good.
The property is located at 7588 County Highway 30A, Inlet Beach, Florida 32461. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7. Property owner is listed as Dune View LLC. Violations cited are 1.13.00A, development approvals, 4.0203, coastal dune lake protection zone, and 5.0406, right-of-way protection. This complaint was received on February 11th, 2026, concerning clearing in the Dune Lake area with no permits. Prior to conducting the initial inspection of the property, research conducted found a previous application submitted to the planning department in December of 2024, and the proposed construction that was presented at the time, which included the decking and stairs around the jacuzzi, could not be permitted since the proposed construction exceeded the allowable impervious surface ratio amount and restrictions within a dune lake buffer zone. Suggestions were made to continue, and the application was placed on hold. No further activity was shown on the application beyond the hold status. On February 17, 2026, an initial inspection was conducted at the property where I gathered photos of the deck and stairs while also observing several items in the right-of-way. After having the right-of-way staked, a notice of violation was posted at the property and sent certified mail with violations found and the necessary actions required to bring the property into compliance. Several efforts were made to get in contact with the registered agent of the LLC, but was unsuccessful in doing so. I was able to speak with the tenant of the property who worked diligently on first removing all items requested from the right-of-way and informed me that he would keep in contact with the property owner to determine how to move forward regarding the decking. An extension was provided due to the tenant's efforts on removing all items within the right-of-way, which eventually was satisfied. After reaching the new deadline, efforts were made to get in contact with the tenant, but could not make contact. Further efforts were made to get in contact with the registered agent, but was unsuccessful again. On June 18, 2026, a notice of hearing was sent certified, and on June 22nd, 2026, notice of hearing was posted at the property and South Walton Courthouse. Photos in your packet show the initial inspection photos and the pre-hearing conditions. Violations 5.04.06 has been satisfied, while 1.1300A and 4.02.03 still exist.
Okay. Do you want to present your packet into evidence?
I'd like to submit my packet into evidence.
That'll be accepted. So everything has been removed out of the right-of-way. You testified. So are we dealing mainly with, you said this extra decking, stairs, and because it looks like the other approval, there was a small deck that was approved?
No, he had submitted, or the property owner had submitted for previously in 2024.
Oh, is this the Exhibit
Yeah.
5, those plans?
Right.
Okay. So those were submitted, but they
Those
haven't
were
been
submitted,
approved?
but they were never permitted.
Okay, that's where
And
I
then
was-
there's an email right after that where it shows the planning department had reached out to him, letting him know why it couldn't be permitted and what was going to be or whatever was going to be required to move forward on it. But I don't think they ever got any more progress on it, so it was just placed on hold.
All right. And you said you had contact with the tenant for some time, but then towards the end that kind of tailed off?
Yeah. Yes, sir.
And do you know, I'm assuming their intent, or does it appear, or I don't know, maybe I'm just presuming things. I mean, is there intent to try to keep that and get it permitted, or is that you just?
Yes, sir. They tell me that they've submitted another application. I don't think they were aware of the.
Yeah, we'll
Okay,
let you
yep.
talk about it. I was just curious. All right. Thank you, sir.
Mhm.
Y'all have any questions for?
We actually talked to you and met each other.
Okay, great. All right, if y'all want to come up, or whoever, wants to speak. And what's your gentleman's name?
My name is Aaron Stillwater, and I'm actually property management, GSM Diversified. In June 21st, we actually came to an agreement because the owner knew that he had issues. So we're trying to get it all right. So
That's right.
Moose, Robert Huntley,
Robert Huntley.
he is a tenant there, and he is operating now in a better capacity than just a tenant. He's helping us make the calls and get the permits because we're in Pensacola. Up until today, I was unknown of the depth of the email communication. Jeff Pate, the land architect, was in attempt to, well, I did know that he had submitted plans, but I didn't realize how many emails there were. He's asking when evidently there's a ratio issue and nobody's been able to get a hold of anybody to determine. So our hopes are, especially since this is a new property for us, is to get it cleaned up. As you see, it's a little junky. It is right there at the entrance, so we would like to make that better. And then maybe be able to sit down with planning and zoning, get a better idea of exactly what our ratios of impermeable surface are, or permeable is what they like to say, which is better. We did apply for a new application. We have been told it is in planning review now, so I'm assuming we can get some kind of meeting at some point. It seems like everybody around here is willing to try to make 30A better, not worse, so we want to be part of that. And then we want to rehab the whole outside. There's additional things, and since we're sitting here, it may take a little longer because we would like to do the septic tie-in and all that, which means we're popping up decks and stuff like that. So I know permits, because shared septic evidently. I didn't know that was such a thing. I guess the condo next to it's shared septic, so now we got to get people all involved, extra people. So this may take a minute, Your Honor.
Sounds like it.
But yeah, so at minimum, we'd like to see if we can get about 60 or 90 days so we can figure out what to do and stay in contact. We are highly motivated because we do intend on turning it into so everybody gets a little benefit from it if we're able to.
Okay.
The part of the issue on why nothing has happened, the tenant, and you would have to speak to this. Did you ever speak to the young lady that was there? Was that one of your tenant contacts? So anyways,
it was Moose. It was just Moose.
Okay. So part of a situation we got right now is December 31st, the owner of Dune LLC, Brian Gerstenberg, he left the property because he separated with his girlfriend.
Okay.
She won't leave. So, and she won't let us do anything. So she's already, she's probably getting served today for formal eviction. We tried to do an amicable one on the 21st when we came, and we posted and hung out, tried to get her to come outside and talk to me, just talk to me. We can do something here. But, so that's pending.
All right.
So we got a few challenges.
Yeah, y'all got a lot of balls in the air. So you just need more time, it sounds like, that you...
That's a heck of a start.
Okay.
Yeah. But without the stress of fines, preferably,
Understood.
because we are trying to, and we did try, evidently, they had tried on the 24th, of 2024, to
Yeah, I see the emails.
come up with a nice plan, and I think that may have actually, you would probably know before I would, that may have come from a complaint from the deck that is there today. So somebody, we'll get with whoever we need to
Okay.
get it moving in the right direction. But it's all brand new for us since June.
Understood. Okay. Well, what's the, let me ask this, what's the county looking for or requesting, considering all the...
I was gonna request just 30 days. Well, actually 33, which would bring it to Monday, August 10th.
All right. Sounds like they're gonna need more time than that, but I understand that's, county's allowed to ask whatever it wants. What's the county requesting regarding fines and any admin fees?
It's $200 per day, and then $122 administrative fee.
Well, this is just what they're requesting. ultimately be my decision on, to go with that request or something else. So they're requesting that you bring the property in compliance within 33 days. That seems like a tall order considering what you've outlined. What are you requesting as far as time? You said 60 to 90?
60, 90, we're dealing with, of course, summer. And, you know, we need coordination. We're trying to get, currently we're trying to determine, you know, can we put a container, a dumpster there? Can we put a construction? Four slot park for parking, and I know during that time, now we're back into watershed issues. So I'm just trying to ask all the right questions before we start doing any kind of work.
Yeah.
Going down or going up or whatever, because I don't want to take apart something that's already done if we can make a modification that makes that thumbs up or what have you.
Right. So you're asking for anywhere from 60 to 90 days to try to, okay, understood. Is there any health or safety concerns regarding the alleged violations that would warrant maybe a shorter time frame than what Mr. Stillwater is asking for?
Not that I'm aware of.
All right. I mean, based on that, I would be inclined to give them more time, even though I know the county wants a shorter time frame, just to get try to get this moving in the right direction. So it sounds like they're amenable to that, to try to, get this resolved as quickly as can. All right, anything else from the county?
No, sir.
All right, Mr. Stillwater or Mr. Hunt, is it Huntley? Okay, anything from you, gentlemen? All right, thank you both. Y'all grab a seat. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 7588 East County Highway 30A, Inland Beach, Florida, is in the unincorporated area of Walton County, Florida, is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I'll find that there is sufficient evidence to find a violation has occurred at the property, specifically a violation of 1.13.00A, development approval requirements, and 4.02.03, coastal dune lake protection zone. Based on the request of the representative for the property owner, Duneview LLC, I will provide that they must bring the property into compliance. I'll give you the maximum amount of time, which is 90 days. So on or before October 6th. That should hopefully give you enough runway to get this resolved. In the event the property is not brought into compliance on or before October 6th, a $200 per day fine will be imposed. So no fines starting today, but after we get past the 6th, there will be fines automatically imposed against the property. In addition to the fine, there's a $122 administrative fee. That'll need to be paid regardless of whether or not the property is brought into compliance. Can you pay that within 30 days? All right, I'll order that be paid within 30 days. No, sir, it gets paid at the code office. So you can either call them, they've got an office up here, they got one down in the south end as well. So, and I believe that is it on that case. Have any other questions?
Will we receive documentation of what you just mentioned?
Yeah, they'll mail you a copy. All right? All right, thank you, gentlemen. That concludes your case. You're free to go. All right, our next case is 25-1897. Property owner is listed as Cal. Is it Cal and the Cardinal LLC?
Cal and Cardinal LLC.
Okay. Anybody here on behalf of the Cal and the Cardinal LLC? I don't see anybody. All right, is the county ready to proceed?
Yes, sir. May I approach?
Yes, sir.
All right. Again, Officer Uriel Baza with Walton County Code of Compliance. For the record, I am submitting my final summary case report and testimony regarding case number 26-01897. The property is located at 2260 West County Highway 30A in Santa Rosa Beach, Florida, 32459. Property owners listed as Cal and the Cardinal LLC. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7. Violations cited are 1.13.06, post-permit changes, and 1.13.09C, building permit. Complaint was about a storm drain. It's filled in with dirt, causing water to flood complainant's guest house. This case was originally assigned to a different code compliance officer, but on January 15, 2026, the case was reassigned to me. After further reviewing the code case and notes, further information was necessary from the planning department to move forward with proper violations concerning murals. After receiving proper guidance and concerns with due process, a new notice of violation was sent certified mail and posted at the property on April 22nd, 2026. The mural was determined not to be in violation. However, additional gravel and a small structure that was moved without proper approvals and permits were found to be in violation. Proper communication with the property owner was non-existent. An email was sent on May 14, 2026 to the property owner's attorney providing the reason for the violation and the necessary actions required to bring the property into compliance. Follow-up inspections were conducted, revealing very little action taken, and no applications have been submitted to the planning department. On June 18, 2026, a notice of hearing was sent certified mail. And on June 22nd, 2026, a notice of hearing was posted at the property and the South Walton Courthouse. An inspection was conducted yesterday, revealing the shed was partially dismantled. There are still a small structure and gravel that exists on the property that has not been approved. Photos in your packet show the initial inspection photos and the pre-hearing conditions where violations still exist. I'd like to submit my packet into evidence.
All right, that'll be accepted. What is the, just so I'm clear, what is the remaining structure? You said that's, besides the gravel, you said there was a remaining structure that was also in violation?
Yeah, so if you look at the last exhibit, Exhibit 16,
Right?
there's, I don't know if you can,
Is it just the?
just like a little storage,
Like, just kind of, yeah, like a.
open storage.
Yeah, open storage that has the ladders.
Yeah.
Leaned up against, so that's the structure.
Yes, sir.
All right, and then the gravel is the gravel from the concrete in between the structure and the concrete parking area?
Yes, sir.
Okay. And so to bring the property into compliance, they would either need to get a development order or approval for that structure and the gravel,
And the
correct?
gravel.
Okay. Have you had any additional contact? I mean, do you know whether or not their intent is to dismantle that or try to?
I haven't had any communication with the registered agent. I was able to contact her through text messages when I first got this case to see if she had gotten the violation from the previous code compliance officer. She said she had not. So that's what made us restart the process on doing a new violation on it, since she was not properly informed at that time. But after that, she hasn't contacted me.
Yeah, it's just, I mean, it seems odd that they would have removed the bigger structure and then left that smaller one.
Yeah, it seems fairly easy to bring it into compliance. I just haven't had any communication other than their attorney reaching out for back in May, asking, what the violation was.
Yeah, I was just curious, they may be thinking that for some, that they're in compliance now because they removed the bigger one, not understanding that the smaller structure would also trigger. That looks less than 400 square feet. Would that still require one? I mean, is it because it's zoned differently? Oh, it's south of the bay? So regardless of the size, any accessory outbuilding or structure requires a permitting if you're south of the bay and commercial. Okay. All right. Anything else?
No, sir. that's
Okay,
gonna be
what's
it.
the county requesting?
Recommendation is, again, 33 days, which would bring it to Monday, August 10th. And that's bringing the property into compliance by obtaining planning approvals and building permit, or removing the gravel and the small structure would also bring it into compliance.
All right. And if it's not brought into compliance, what's the?
If it's not brought into compliance, a $200 per day fine to accrue. And then there's also a $122 administrative fee.
All right, thank you, sir. All right, at this time, I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 2260 West County Highway 30A, Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, is therefore subject to the Walton County Land Development Code. I'll find that sufficient evidence has been presented to show a violation has occurred and is occurring at the property, specifically a violation of 1.13.06 post-permit changes and 1.1309C building permit requirement. Based on that, I'll order that the property must be brought into compliance on or before August 10th. Should the property not be brought into compliance on or before that date, a $200 per day fine shall be imposed. I'll also order that the administrative fee of $122, that'll need to be paid regardless of whether the property is brought into compliance. I'll order that be paid within 30 days. And I believe we're on maybe our last case, 260193. This is Sarah Waite and Jordan Flournoy. Address is 15 West Firethorn Circle in Inland Beach, Florida.
Yes, sir. Officer Uriel Baza with Walton County Code Compliance. For the record, I am submitting my final summary case report and testimony regarding case number 26-00193. May I approach?
Yes, sir.
This property is located at 15 West Firethorn Circle in Inlet Beach, Florida, 32461. Property owner is Jordan Flournoy and Sarah Waite. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7. Violations cited are 1.13.06, post-permit changes, and 1.13.09C, building permit. We received a complaint on March 20th, 2026 by phone for installing a prefabricated building in the backyard without proper permits. Research conducted prior to initial inspection reveals no recent permits or approvals found for a small building in the backyard to a 2024 built home. An initial inspection was conducted on March 25th, 2026, where a small building was observed in the backyard of the home. I was able to contact the property owner at the time of the initial inspection, where he informed me that he would reach out to the planning department to begin the after-the-fact permitting of the small building. On March 31st, 2026, a notice of violation was sent certified mail and posted at the property the following day, with the violation cited and the corrective actions required to bring the property into compliance. The owner applied with the planning department, but was later declined by the HOA after a board meeting was held to decide whether the building was allowed or not. On June 18, 2026, a notice of hearing was sent certified mail, and on June 22nd, 2026, was posted at the South Walton Courthouse and hand-delivered to the property owner. A pre-hearing inspection was completed yesterday, revealing the pool house had been removed, but its foundation still existing, which has not been approved. Photos in your package show the initial inspection photos and the pre-hearing conditions with 1.13.09C being satisfied and 1.13.06 still existing. I would like to submit my packet into evidence.
All right, that'll be accepted into evidence. So the foundation is this concrete pad?
Yes, sir.
Okay. Have you had any contact with the owners?
So I was actually able to contact him this morning, where I did inform him that he would have to remove the pad as well to bring it into full compliance, since that's still in violation of the post-permit changes.
Okay. And do you know whether or not they're going to do that, or are they going to try to seek a permit to allow?
I think he's
remain-
weighing his options right now.
Okay. All right. What's the county requesting?
Recommendation is to bring the property in compliance by Monday, August 10th, 2026, by removing the foundation or obtaining approvals through the planning department, a $150 per day fine to accrue if not brought into compliance by the deadline given, and a $122 administrative fee.
Did you advise the owner what you were going to recommend today?
Yes, sir.
Okay. Did he respond or say anything? Yay, nay?
No, sir. He's just trying to see if it's worth trying to keep it or not.
Okay. And did he give you a reason why they weren't coming?
Well, he did tell me prior to having the house removed that he would, either way come in compliance by the time given.
Okay.
So he didn't see any reason to.
Understood. All right. That's fine. All right. Thank you, sir.
Mhm.
I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 15 West Firethorn Circle in Inland Beach, Florida is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that is sufficient evidence show a violation has occurred at the property, specifically a violation of 1.13.06 post-permit changes. Based on the county's recommendation, I'll order that the property be brought into compliance on or before August 10th. Should the property not be brought into compliance on or before that date, a $150 per day fine will be imposed. In addition to the fine, there's a $122 administrative fee. That fee will need to be paid regardless of whether the property is brought into compliance or not, and I'll order that be paid within 30 days. I think that is it for our agenda and the open cases. I do have some orders to sign that are up here. I'll do those offline. We're adjourned.